One.
Good morning, everyone, and welcome to our March meeting of the Division of Oil, Gas, and Mining Board. I'll just go through the agenda real quick so that everybody has a sense of what's going on, because this is a little bit different than our normal hearing. We'll go through our normal briefing process. Whoops, that's right, that's April. We'll go through our normal briefing process, and we have the division will talk, then we've got the couple other items there, and then we'll have an opportunity for public comment. Then we have two docket items. Both are related to mining, and we will be talking about the bonding issues there. And then we will probably finish those sometime between 9:30 and 10:30. And then we're going to switch gears, and we're going to do a session on the oil and gas bonding rulemaking comment period. So we'll give everybody another chance to talk about that. The agenda that I have for that includes nine speakers, but we're going to start with when we go to that session, we'll start with the division, and we'll have the division talk about the revisions that they're dealing with right now. Then I'll just take them in the order that I've been provided. That was Holly Hill, then Drew Levine, Fred McDonald, Ricky Renko Browning, Spencer Kimball, Matt Lepore, Lauren Beatty, the Western Leaders Network, and then Tyler Work. And if you guys want to rearrange that for some reason, let us know that. We'll probably take a short recess before we get started with that. I would ask all of those folks that are going to speak, we'd really like to get this done before we take a lunch break, because just have continuity. So if you could keep it to 10 or 15 minutes of comments, that would give us an hour or hour and a half to 2 hours of content on the bonding rulemaking comments. I want everybody to have an opportunity to say whatever they need to say, but we'll try to get that done. If we don't get done by 12 or 12:15, we'll take a lunch break, and then we'll come back and finish up. So with that, let's go ahead to the briefing session. Mr. Thomas.
Thank you, Chairman, members of the board. Again, my name is Mick Thomas, Director of Oil, Gas, and Mining. I have next to me Natasha Baliff, who's, again, wearing a number of hats. Today, she's our legislative liaison, and she will answer any questions that come up, and then she will also be the one to address the 5-year renewal of abandoned mine reclamation. But moving forward, the session is over. Excuse me. This was my third session, interestingly enough, that I've completed. Isn't that fascinating?
Yeah.
I'm an old hand at this point. It was robust, a lot of work up front, and then sort of a lull, and then the last 6 hours was typically crazy. But we're glad it's over. The board and the division had some meaningful achievements during this session, providing some clarity and some rules, and also building out a significant amount of critical mineral guidelines, some resolutions. We were successful on some funding fronts, but I want to go through this presentation with you and just talk specifically about some of the highlight bills that were passed. First, House Bill 437, Environmental Permitting Amendments. This is something we've spoken about before, and it enables the division to provide and provide staffing for the division to provide additional resources to operators to ensure their permits are complete before they're submitted and accurate. The bill allows the division to create a number of reviewers so that an operator can come in, either hire a vetted reviewer or permitter to help fill out the permit so that it's accurate and adequate. And then the division vets, again, the division has vetted those. Especially on the mining side, we find operators who inadvertently and not intentionally are in sort of a start-stop environment where they submit a permit and there could be a miss, an inaccuracy, or an omission. These are not the operator's faults. I think we all understand that operators do best when they are extracting resources and having meaningful economic impact to the state. Knowing the state's regulatory program as well as the federal regulatory program, we're the experts there, and I think we could provide a higher level of customer service to these operators to ensure things go faster. House Bill 437 basically codifies that concept. House Bill 530, State Permitting Council. This is along the same lines. There's a permitting coordinator within the Governor's Office of Economic Opportunity. For clarity, and I have shared this before, this permitting coordinator is an enabler. They do not have a dedicated authority there to direct a permit to be approved or denied. And there was a carve-out in this bill to ensure that the board and all of your powers and responsibilities are excluded from any sort of jurisdictional conflict with the permitting coordinator. The primary goal of this permitting coordinator is really for infrastructure, if there's a right-of-way that's needed, and really to help and assist the Department of Environmental Quality, you make sure they have the resources they need to complete their part of the permit. It also enables, at some point, maybe it was the last bill, well, I'll talk about that. I think the next slide is this. But this coordinator, again, serves as a liaison just to make sure that everything's going smoothly. Sometimes operators especially our federal partners, like the ability to call up and see what's going on. And this liaison will be, this permitting coordinator will be that person. 234, this is what I was getting at in a little bit. We're fast-tracking permitting. Up until now, sometimes there was where OGM would finalize a permit and then it would go to DEQ or vice versa. This bill ensures that both DEQ and operators can work on whatever parts they can concurrently. Hopefully this will speed up the process significantly. A lot of these bills were designed to enable DEQ to move quicker. The new director, especially Tim Davis, is very eager to do this. He understands the importance of saving time during the application process because it reduces the overall capital expenditure. And we're happy at the division to be a partner with that. Later on today, I think either early tomorrow or later on today, we have an initial meeting with this group. We have a dedicated permitting council that we're going to work with DEQ on to ensure that everybody's on the same page and moving appropriately. Finally, to develop the critical mineral industry, which is a big thrust of the governor over the past 18 months, we have a council that's going to come up and, again, try to streamline a lot of the processes here. We're going to develop a mine center to help critical mineral operators de-risk some of their operations up front. And the division especially has been tasked with the creation of a critical mineral atlas. We have some initial comments, initial ideas on what this atlas will look like, but this will be a public-facing atlas that operators and the public can come into and see sort of a dashboard of what potential there is in the state. It's more than just where are the rocks. Hopefully we'll be able to include what water rights are available, what water rights are not available, what easements are available, who owns the land, what's the infrastructure look like. We really want a global view of the entire industry and site so an operator can make a good decision. SCR 4, concurrent resolution regarding permitting of oil and gas and mining. This is something we've talked about, and this is a cooperative agreement between OGM and the Bureau of Land Management to help them complete the federal side of the permitting faster. We do have some dedicated staffing that was awarded to us during the legislative session to allow for this. We have had ongoing conversations with the Bureau of Land Management, not just the deputy director and director, but also the field staff last week to make sure we're all on the same page there. It's moving along very well, as well as you can with a federal agency. Sorry, Selma, it's just a call out there, but I think you get it. Given the amount of effort, and as you mentioned last month, this has been a multi-year, perhaps 15-year process, and it's just slow, steady pressure. That's how we do it to help things move along. And that's it. I appreciate your time. Do you have any questions about this presentation before we move over to Ms. Balliff?
Yeah, on that enabler for, did they fund that position? Is it taken out of Hyde?
The permit coordinator with the governor's office.
Yeah, governor's office.
There is funding for that. It doesn't come out of any of the OGM budgets. This is part of the larger critical mineral bill that was passed.
Okay, and you got some additional staffing for SCR4?
We did. Holistically, the division saw a increase in FTEs of 8 to help not only the mining side but also the oil and gas permitting side. I know we've talked a lot about critical minerals, but the reality is, you all know, oil and gas is a large financial contributor to the economy of the state. It has grown substantively in the past 5 years, while our staffing has remained relatively constant. We have amazing field staff doing inspections and a lot of things out there. I can't give them enough credit, but man, I want to give them some oxygen too.
Okay, and then HB 437 and 234, were there any funding or additional staff on those two?
For example, up there now is 234, the fast track permitting. We do have, again, the 8 FTEs that we put in for as part of the governor's budget were set there in anticipation of these bills being codified. So we don't have dedicated FTEs associated with each one of these bills, mostly because we had already anticipated that and hoped for it.
Okay. All right, good. Thank you.
Thank you.
Go ahead, Selma.
What's the current timing for approving a permit at this point, and how much more? I know it changes from time to time, depending on the circumstances, but on average, what's the timing for approval of a permit?
Well, it depends on the permit. Oil and gas, I think we're at 45 days. Mining, we're a little bit longer. Let me lean back and look at Dana real quick. Hey, Dana, sorry. What's the average permitting time for a mining permit broadly?
It depends on the permit, but small mines, 30 days. Large mines, 60-ish.
That's what I was thinking. Okay. Yeah. Again, I phoned a friend with our deputy director Dana Dean, and for the record, small mine permits about 30 days for initial review and potential approval. Large mine permit, it's shooting for around 60 days for the first round. Those are great times compared to maybe some of our other partners.
So that the coordination between the BLM, because I see it out in the basin, that permitting, that the BLM could use additional help. And so do you see using, state specialists to expedite any permit modifications, and then it just goes through then still goes through the signature there?
Chairman, Greg, you're right. The BLM and the federal partners do need additional staffing. They've had their staffing stalled to reduced while being expected to move quicker. It's the reality of it. And the environmental assessment, the site assessment, species, botanist, they have a number of needs that the division and really the state can assist with. This cooperative agreement we're working with specifically is focused on us giving a vetted permit to them based on shared criteria. But there's already a process in place where federal partners in the state, our federal partners in the state FTEs can share resources. The state has the ability to, like if we had, for example, someone with a skill in botany, which is dearly needed from the federal folks that I've talked to, we can put someone over there to help them out. They also have a strong need for petroleum engineers. We don't have a robust PE staff right now, but we are taking steps to increase that by at least 1, maybe 2 over the next 6 to 12 months. So we will continue to assist them wherever possible. That's been ongoing. I think a lot of it, though, Chairman Greg, is just increasing that communication. It's best achieved informally. They can run it to us, and if our staff have bandwidth, we're eager to help. I'll say it again. Our staff knows state laws very well. Our staff knows federal laws very, very well. we're really quite fortunate to have the team we have.
Working from both the state and federal agencies, the state, it's night and day as far as how you can, the permitting process is much faster with the state.
Yeah, you're right. And I see that almost across all states, except for some west of us. Generally, the states are much quicker.
NEPA is the key here.
You're right. You're right,
And-
it is.
But if I read correctly, at the federal level, they've just recently passed some policy that will revert NEPA to its original intent. Now, that remains to be seen, because right now it's being used as a tool against federal management practices. And so now if they go back to what it was intended to be like, it should help speed up the process. But that's been the major stumbling block for working with the state and the federal agencies. But maybe with this, plus the state legislation that you just talked about, and streamlining the NEPA process, that is an ideal situation.
You're correct. Chairman? Thank you. That concludes my presentation for the legislative update. I'll shift it over now to the 5-year renewal of Abandoned Mine Reclamation Program rules from Ms. Natasha Baliff. Go ahead.
Yeah, I guess for the record, I'm Natasha Baliff. I'm the Legislative and Planning Coordinator for the division, and I'm asking for your permission to renew our abandoned mine reclamation rules. Right now we have 8 different sections that need to be renewed, and this is something every 5 years. The Office of Administrative Rules just wants us to evaluate everything, make sure they're still applicable, they're still needed. All of these are influenced federally, and so we really don't have a lot of say on what rules we need to have in place, and what they say. And so this one is kind of a more simple one where we're just saying, yes, we still need these rules in place so that we can still have an AMR program. One of the questions on the form asks if we have received any comments on these rules since the last time we did our 5-year renewal, and we haven't heard any. There hasn't been any issues with the language that we have in place. So I'm just coming before you today to get permission to renew the rules and keep them in place for the next 5 years.
Okay, down on the mining side of the house, any questions of Natasha on these rules?
Yeah, one quick one. You know, like you say, as far as was there a public notice seeking comment on on the renewal of the rules of the regulations?
Yeah, we do usually send out emails just blanketly saying, hey, this 5-year renewal is up. If you have any comments, let us know. We very rarely receive comments back that way. And then just kind of procedurally, usually if there are comments, then we address them a little bit down the road after we've renewed them and put them back in place, and then we can make any edits that way. So if there were any, we could address them, but we haven't received anything.
Okay.
I guess I have 2 questions.
Yeah.
One would be, you talk about renewal. Are there any kind of updates required at all?
No. So this one is really just, they want us to review and make sure they're still needed. And yeah, doing it every 5 years. So now we just have a cycle of each program has their own year. This one is just for abandoned mines.
Okay.
Yeah.
And currently, how many different operations would be in that category that have been abandoned?
So this wouldn't be, and maybe someone else can jump in if I'm saying things incorrectly, but there's not any operations. There's not like operators that they deal with. They just go in and find abandoned mines. Usually these are decades old, and they just make them safe for the public. They'll close them off so people can't get in there and stuff like that. So I think it's more project-based, not operation-based.
More underground or surface focused?
Both. I think
Both.
it depends on the opening of the abandoned mine.
Okay, thank
Yeah.
you.
I would like to follow up and provide some supplemental comment. Thank you, Natasha, as specifically Chairman, to Commissioner James. These rules enable the department to basically facilitate and complete our AML, our abandoned mine lands mandate. You understand that, by definition, there's not an operator involved, right? Mm-hmm. And so the rules just will continue the guidance for the program that honestly has been doing very well and very well. I don't want to say adequate, amazing over the past 5 years and before that, and will continue. But sometimes tweaks are needed, and so we invite these rulemakings so that modernization can occur.
And primarily, sorry.
About how many of those projects occur annually? How many do you guys do?
That is a really good question that I don't have an answer for.
Between 2 and 6 from
Okay.
a random person behind me who may know.
Thank you.
Well, it's a little off track, but funding and projects is primarily based upon the budget and how much it is, and it's primarily federally funded, isn't it? And so that's why you have to, renew it with the. But is it considered that we have primacy on it? It's just that we have primacy over the projects, but the funding comes from the federal government.
Correct.
Yeah. Yep.
Anybody else? Okay, so if I understand this correctly, you want us to make a motion to approve your renewal of the Abandoned Mine Reclamation Program rules.
Yes.
So before we do that, I think then it might be appropriate to see if there's anyone from the public that wants to make comments at this point in time on this. This has been on the notice for 45 days or so people should be aware. Okay, I don't see anybody here. Matt, do you see anybody on the
If we do
outside?
have anybody online, just hit the raise your hand button. I do not see anybody raising their hand, so I think we're good to go.
Okay, doesn't appear that we have any public comments from people here in the house or outside. Board, do we want to deliberate this, or how do you guys feel over there?
I'll make a motion.
Okay, go ahead.
I'll make a motion that we renew the Abandoned Mine Reclamation Program rules for another 5 years.
Second.
It's been motioned and seconded that we approve the Abandoned Mine Reclamation Program rules. All those in favor say aye. Aye. Any opposed, say nay. Okay, the motion carries. Thank you.
Thank you so much.
Thank you, Natasha.
Okay.
Thank you, Chairman. Next item on the agenda, the other category. A few things I'd like to bring up for the board. Ongoing success we've had modernizing really the customer service and the data that we provide operators. While we are the chief regulatory agency for the state over oil, gas, and mining, the bread and butter and the real value comes out of the data we provide operators on oil and gas and also mining. We have taken meaningful steps to update our BDMS system, which includes permitting, hopefully a plethora of oil and gas data that the operators can access, because as you recall, operators use our data to make real-time capital investment decisions. The better quality, the more accurate, more up-to-date data we can provide them helps support the industry significantly. We're in some pretty good talks with the Groundwater Protection Council, who does, and it's a nonprofit, as you may know, who operates the RBDMS system across the nation. We're the only state who hasn't really shifted over fully to their modern suite, and we're taking steps to do that now. In fact, in a meeting with the Department of Interior last week, I learned that the Department of Interior is also looking at their system as a means to help the federal side. So it's a win for them. And we're also very excited about one or a few of the artificial intelligence initiatives we're taking at the division. We are working with Google and one of their contractors to build out a in-house enterprise Gemini enterprise suite that's isolated from the rest of the world. Right? It's a closed system that specifically focuses on enabling our staff to use artificial intelligence to vet the initial to do initial vetting on the permit applications, so that they can do what they do best, and that's solve problems. we hope for significant increases across all programs in permit review and acceptance using the artificial intelligence system. In fact, Utah is the initial state, I would say right now the only state, moving forward with this type of concept. As a result, I've been asked to speak, hopefully briefly, at the Google Next conference in late April in Las Vegas to talk about how Utah is leading the way out on the use of AI to make things faster and better. We're pretty excited about that. And we were granted some fundings during this legislative session to help move that ball along. So that's my other comments. Those are my other comments. If you have any questions about that, please feel free.
Okay, to get to the full update on RBDMS with GWPC, do you have the funding for that, or do you have an estimate on what they're going to ask you for to get that full update?
We do have ongoing recurring funding for that. The time frame, conservatively, we're hoping max maybe 12 to 18 months, hopefully sooner. One of the benefits of the GWPC RBDMS system is because they're nonprofit, once they build it in another state, well, we share the love, right? You see how that comes out, right? And so there's a significant cash savings there. Current estimates are very speculative. Overall total cost under $5 million, hopefully significantly less. And then again, that will be spread out over whatever time it takes to implement it. But we do have funding for that.
Okay. Because in California, we spent $60 million.
I know. And then I think walked away from it. Fascinating.
Yeah. Okay, go ahead.
At the UPA conference, there were a couple of really good presentations, one by Enveris, and then another one by the University of Utah, actually Alan's group up there.
Yeah.
And using our data is what they use to, the Enveris presentation showed inventories in all the states for all the different basins. And, it's based on how we're drilling right now, the amount of inventory that there is. It was interesting. It's kind of sobering to see that, there is a limit on it based on our current technology, but our technology is always evolving. We're finding more places to drill. So we know that what we know now is not what we'll know in 15 years, but it does. But that inventory and then the different types of rock and all of that, and the professor that was modeling up there, showing all the different layers in 3D. It was really cool. Anyway, so yeah. Our data is where they get that. So the quicker we can, the better our data is, and the easier it is to obtain, is a big deal.
Chairman and Commissioner Moon, you touched on something. I'm glad you brought that up. It's not just an OGM sort of goal. Tim Davis with DEQ also agrees with this. And one of our hopes in the medium to long term is to set up a permit status dashboard, so folks can log in and see, especially on the oil and gas side, but across all programs, where is the permit, right? Because if you're trying to schedule a rig, it really helps to know, what the time frame looks like. If we're shooting for 45 days, that's really close to where most of them land. Sometimes they're sooner. Sometimes they get a little hairy and they take a little longer, right? And having that dashboard across DNR and DEQ will help the operator. That's our goal there.
Mm-hmm. And then one other just quick thought with that. Most wells are considered confidential for the first year.
Yeah. And
so just the idea of, is that year confidentiality necessary with as many wells as, I understand an exploratory well, there's some desire to keep, trade secrets, but the sooner we can put the information out there, the sooner it can be evaluated by all these different groups to help operators be more efficient in where they drill and how they drill. Just all of that data, the quicker that it's out there, the better. So, everything we can do, Fred back there, if they're, how important is it to operator? Or is it just a box they check automatically on any new well? Is there a way to lower that confidentiality time period, and how soon we can get information out? Because things change fast, and they're changing for the better. but they can change faster if the information's out there. So, yeah.
I hope that is a completely rhetorical question toward the division, because I am not going to take a position on the confidentiality timeframe of wells. But it is something that, of course, we always invite the board to deliberate, invite public comment on, and there could be rule and statutory changes that are needed to modify that. But I would say broadly, it's good for every state to evaluate the best operating practices for their industry while protecting the Utah or protecting the citizenry. So that's as much of a non-answer as I could give. I hope you appreciate that.
Yeah, I get it.
I'd like to say at the UPA conference, I was approached by a few people who complimented you on the quality and the quantity of the data that's available and the ease. It's getting better all the time, but it's easy to access, and compliment you on being a leader in this information distribution area that I think a lot of companies would like to see instituted in a lot of the other states.
Well, you know this, Chairman Levon. It's all Dana and Jen and their team. It's a treat to work with them, and they're driven to do exactly what you said.
This group is very innovative.
Yeah.
I mean, you're doing a lot of things that other states are just like, wow.
True.
And
Our produced water video that we showed, I think a few months ago, it's been on our YouTube page for a while, talking about how we're recycling produced water. That got all kinds of traction at the GWPC conference, and will in May at the IOGCC conference as well.
Yeah, the thought processes that these employees go through, going,
True.
well, if we can do this, we should be able to do this.
Yeah.
And then innovating it. And the whole staff should be complimented on the great job they do.
I agree.
Very proud of that group.
Thank you. On behalf of them, thank you.
Thank you.
Anybody else? Okay, it's not just industry that's scraping your data.
True.
Research, academia is where you're scraping your data, and I'm sure there's lots of commercial parties out there getting it and marketing it. So,
Welcome.
and the secret is how do you access it and find it, and
Right.
and and then utilize it. So, okay, anything else? Okay, next month's agenda.
Next month's agenda, our next board meeting is going to be on Wednesday, April 22nd. It's here in Salt Lake. We have a number of agenda items,
3.
docket items already built out. Let's see, 3. We'll see what pops, right? But that's the next meeting. And I do not have any additional comments beyond that. If you have any final questions, or it's back to you, Chairman.
Okay, all 3 of those are on pretty much oil and gas, so, all right. So with that, we'll have the opportunity for any kind of public comment. This is the time for anybody from the public that has other issues that they want to talk about to the board. We're open for that right now. So anybody from the public here that wants to make a comment now that don't already have time reserved for the 10 o'clock session? I seeing none. Matt, do you have anything on the?
We do not
Online?
have anyone online for current public comment.
Okay, then we will go ahead and proceed with the 2 docket matters. Thank you guys for the update on the very informative briefing session. Okay, so the first agenda item is docket number 2026-16, cause number S0250032, in the matter of the notice of agency action wherein the Utah Division of Oil, Gas, and Mining requests the board issue an order forfeiting the bond covering the Emerald Green Mine, permit number S0250032, located in Kane County, Utah, and authorizing the division to reclaim associated impacts from the operator, Michael L. Caruso, and authorizing the division to take any and all action necessary to recover insufficient reclamation costs. We'll take appearances for the division.
Assistant Attorney General Gary White here on behalf of the Division of Oil, Gas, and Mining. and I'm here with Division Expert Kim Coburn.
Okay. Is there anyone for the mining aspect for the Emerald Mine? Any parties? Anything online, Matt?
No.
Okay, go ahead and proceed, Mr. White.
Thank you, Chairman Walker and members of the board. We're here today on a matter seeking bond forfeiture for the Emerald Green Mine. This is a photograph of the mine site, and I'll ask Ms. Coburn to provide some additional details to the board about where this is, and we have a map that we can show as well.
Yeah, swear in the witness.
So this mine
Okay,
is
hold on
just,
a second. You want to go ahead and swear in the witness?
Oh, go ahead.
Would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Go ahead and proceed then. Thank you, sorry.
No worries. This mine is to the northwest of Orderville, Utah. What you see here is the reclaimed site where the operator tried to do the reclamation as best as they were available to be able to do. This is what we're left with on the ground right now. It's a couple miles up. Let's go to the map to kind of show. So this access road is about 2 miles from town, but it's not a very good road. I have gone all the different ways on there, and it washes out regularly. And sometimes I've even just parked and hiked. It's one of those very hard to access roads.
Thank you. So some background facts about this mine. Emerald Green is located on Trust Lands Administration property in Kane County. The operator is an individual named Mike Caruso, who has not appeared today. The purpose of this mining operation was to obtain septarian nodules at the site. The bond amount is $8,000, and that's held with the Utah State Treasurer for the bond here. I believe we have a representative of Trust Lands here, but the operator no longer has a lease with Trust Lands as of 2022, and a letter was submitted after we filed our notice of agency action from Trust Lands indicating that they agreed that this bond forfeiture should be granted and the site reclaimed. Just some history on what's been happening here. Back in January of 2023, the division ordered this operator to complete reclamation of the site by June of 2023, which consisted of revegetation and seeding work to be done by November of 2023. The operator later asked for bond release for that $8,000, but before granting that request, the division, at the behest of the Trust Lands Administration, issued a letter dated September 5th of 2023 requesting additional reclamation work. The main issue here is the mitigation of Russian thistle or tumbleweed at the site. The division later issued a directive that the operator spray those weeds with a, how do I say that word?
It's a glycophosphate herbicide.
Thank you. I don't know what that is, but apparently it kills tumbleweed.
It's Roundup.
Yep. It's just Roundup.
It's Roundup. Oh, why didn't we put that in here? Okay. So to kill those weeds and reseed the site prior to snowfall, that was the hope in 2024. Unfortunately, an inspection from November of 2024 revealed that the site still contained unacceptable number of those weeds. The operator submitted photo evidence, and we have the photo here of raking at the site in August of 2025, and they indicated that they had attempted to reseed in the spring of 2025. However, an August 2025 inspection revealed that although the site was raked, the herbicide had not been applied prior to the seeding, and the tumbleweed is still at the site. And since that time, despite numerous attempts, the division has been unable to contact this operator. And here's a photograph of what the issue is out at the site. This shows the tumbleweed and how it's kind of taken over this area. The applicable law here that supports the request for bond forfeiture is Utah Code Section 40-8-14, which indicates that if an operator fails or refuses to perform its reclamation, the board can declare that surety forfeited to the division. Under the administrative rules, Utah law also allows the board to forfeit a surety if the board finds that an operator has violated the Mine Reclamation Act, which would be 40-8, a division order which has been issued here and has not been followed, or other administrative rules. So based on the evidence, the prior orders and existing law, the division would request the board issue an order declaring that this operator has failed or refused to complete reclamation, order that the $8,000 bond be forfeited to the division, that the division then use that money in conjunction with trust lands to conduct reclamation at the mine site. And in the event that there is additional money needed to complete reclamation, that the division be allowed through the Attorney General to seek civil penalties and reclamation costs in court, in a district court.
Mm-hmm.
So does the board have any questions?
Go ahead.
Just curious, when you require the use of that Roundup to be used out there, isn't it pointless to do reseed because the herbicide or the Roundup is going to kill those seeding opportunities?
So in the instructions, we were having them apply the Roundup in the spring with a fall reseeding. It gives it time for the Roundup to dissipate. And that's why we are here today, because we gave them like that year to be able to do all that work. And the operator legitimately went out there and tried by hand to do it. They don't have any of the equipment. So part of this request, we're working in conjunction with our partners at SITLA. We're giving it to their rangeland specialists, this bond, that's our hope, so that they will be able to go out there as part of a larger effort to be able to go and reseed this area and spray it and do it everything in conjunction so we can get better reseeding. Can you go back to that photograph of the overview of the mine? So on slide 2, please. On the site, the tumbleweed is only really observed at this mine site, and everywhere around it doesn't really have the tumbleweed. So we're trying to contain it so it doesn't become a problem for the rest of SITLA's land, and that's the main concern that they have. They want to make a nice grazing habitat for the cows and everything else that go in the area.
How big is the area?
So the operator was mining in 1 acre increments. This area that has been disturbed that you see on your screen is about 2.5 acres. There is some areas up the hill that does not have the tumbleweed. Altogether, there's about 3 acres disturbed. We're mainly concerned with those 2 acres. We would
because
like
a hand rake on 2 acres.
Yep.
It's a long process.
It truly was.
Yeah.
But they don't have any
But they had
equipment anymore.
$8,000. They could have got spent and then got their bond back.
Yep.
And they didn't. So yeah. Okay. Yeah, because it's going to take $8,000. I mean, to really
It will.
get it ready and prep it and seed it, and yeah.
So has SITLA accepted the responsibility of these funds and managing the reseeding and Roundup effort? Who's going to do that?
SITLA and their rangeland, they have accounts for that set up. So once this is forfeited, we'll be transferring it over to them so that they can go out there this spring to spray, and then the reseeding this fall and be able to manage it better.
Thank you.
Go ahead.
So as far as the actual work, see releasing the bond, I'm glad you answered the question of, I was going to ask how it related to the area around it. So it is focused, the noxious weeds are focused in that area, just that. Who's going to conduct work, SITLA or?
Yes.
Okay.
So Trust Lands Administration, and that's why we have some representatives here today.
Right, yeah.
They're very supportive of this effort.
I'm going to talk to council just a second, off the record. Okay, so Mr. White, there are about 7 exhibits that are listed with this request for agency action. Are you going to review those with us? or offer those as evidence? How do you
No,
want?
there's no need to review those as part of the presentation. They're essentially distilled in the PowerPoint, but we would move to have those admitted for the official record.
Okay. And members of the board, those exhibits are available, or they were, presented to you all electronically, so those are offered as evidence, okay? And we'll admit those as part of this, okay?
Thank you.
Yeah, okay. So on the letter that we got from the trust lands, can you go ahead and, Exhibit 3, can you talk a little bit more about what the trust lands was talking about there?
Just the order, we want to make sure that they had clear.
Let me find it.
So we actually have the individual here that wrote the letter. So this was a letter of support for these reclamation efforts.
Is somebody from Trust Lands here? Okay. You want to come on up?
And we do want to hear this as well, because we want to make sure they accept that they're going to clean it.
Yeah.
But we do want the division to talk about that they have knowledge that the mining person was aware that they had been ordered to do this and they didn't do it.
Okay. Let's take, want to swear him in, please?
Would you please raise your right hand? Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Okay, can you please identify yourself and who you work for?
Andy Bedingfield, Utah School Trust Lands Administration.
Okay, great. Okay, can you make some references to the order that you're seeking and the letter that you provided to the division?
Yeah, we're supportive of this docket number. 206-016, cause number, that's the mine permit, S02500032.
And do you agree with what the division?
Oh, yes. SITLA is very supportive of this effort. In fact, our rangeland specialists, we do a lot of spraying of weeds on our lands, independent of reclaimed mines. This area has been a particular problem. We don't want to see these weeds spread to other, not just trust lands, but the federal lands around it.
Mm-hmm.
We have a rangeland specialist in our Richfield office that can do a lot of this work, spraying the glycophosphate from an ATV rig and then reseeding it in the fall. So we're very supportive of this effort, yes, Mr. Chair.
Okay. All right, great. So, and just for everybody's, it's glyphosate. My son makes it, so I know that very well.
Yes, sorry.
Thank you.
Thank you.
Yeah. All right. Okay, and then also, Mr. White, could you talk to the letter ordering reclamation? That is the Exhibit 3 that you offered.
Let me pull that up.
Yeah, we just want to make sure that
Mhm.
we know.
And this would have been notice provided to the offender, if you would.
We're getting there.
Board, while we're waiting for there, any other questions for Trust Lands?
Yes.
Go ahead.
While we're here, as far as the process, a couple of questions. Like the $8,000, as far as when the bond's calculated, is that done through SITLA or through DOGM?
So the bond was calculated using our per acre costs for 1 acre of disturbance. And they ended up having 4 acres of disturbance afterwards, and it was $2,000 an acre for the reseed afterwards. So that's how we got the $8,000 today. What happens is, to answer your question regarding SITLA, is the division calculates and requests concurrence from our partner agencies. So we requested concurrence from SITLA, who agreed upon that, along with, we would do the same for any federal partners if they were involved. So it's a cooperative process. Sometimes they require more, and sometimes we require more, and we go with whatever number is higher that the agencies need.
And so in something like that, who's the lead agency as far as, is it SITLA or dog them when it, so I guess Sitla's, I'm just trying to understand better the relationship between, you know, the two agencies.
So our goal is to ensure reclamation of all mines in the state of Utah if needed, if an operator abandons the site. And we want to facilitate that as much as possible. So we work closely with our partners. On this site, the operator has done work. They have done the earthwork, but we've been struggling on the re-veg. And so in order to protect Sitla land in the area, we are working closely with our partners, and they have their own mandates to be able to use this land to help generate money for the schools. This generated a lot of sectarian nodules, and they also have multiple use, such as for all the grazed land.
Okay, thank you.
So were they successful in finding some there? Was it?
Yes,
Yes.
there's known septarian nodules there. If you're not familiar with those, they're rocks of various sizes. They cut them in half, and you'll find them in like gem
looking 'em up,
shops
huh?
and stuff. Yeah, they're really cool.
Okay. So it was a successful mining deal.
It was successful enough, I guess.
Good.
Yeah.
Mr. Bedingfield, does Sitla carry any supplemental bonding beyond the 8,000, or do you rely on Dogum to carry the bonds for this project?
Great question. In this case, we have no supplemental bonding on this project, so it would be all the bond held by the division.
Thank you.
Yes, there are instances where you guys hold the bond, or we do. We let the operators choose. Sometimes operators choose to hold it with the BLM or anyone else. We try not to double bond the operators. The operator gets the choice. So if they have multiple different permits with the BLM or with Sitla, a lot of times we're the holding for it so that they don't have to post with multiple agencies.
Okay. Okay.
Chairman Walker, to answer
Back
your
to Exhibit 3, yeah.
Exhibit 3. So Exhibit 3 is distilled on bullet point 1 in the presentation here. This is the January 2023 letter. The letter discusses the fact that this operator has lost access or right of entry to the site. And then the division orders what's stated there on the bullet point, that the reclamation needs to be completed by June, with revegetation seeding work to be completed no later than November of 2023.
So I guess as evidence of they did receive this because they went out there and attempted. They were not successful, so I guess we would presume then that notice was provided and notice was confirmed.
Correct.
Just they were not successful. Okay.
Could I ask one other question? If the costs exceed $8,000, is Sitla accepting the responsibility? You're not going to come back to the division looking for additional money?
No, we would not come back to the division. We would use the money that's available, and then beyond that, it
And
would
roll
come
it
out
in.
of our own.
Roll it into your program?
Correct.
Thank you.
Okay. If anybody on the board wants to see this, I've got actually Exhibit number 3 here. If anybody wants to see this letter to Mr. Caruso. But yeah, okay. All right. Go ahead, Mr. White, then go ahead and sum it up.
Thanks, Chairman Walker. So with that, we believe the evidence shows that this operator has in fact failed to reclaim, and we would therefore ask for an order declaring that that reclamation did not take place, that the $8,000 bond be forfeited to the division, and we would request in that order that the division be allowed to conduct reclamation of Emerald Green Mine. And as you've heard today, that will take place in coordination with trust lands.
Okay, thank you. Board, is there any reason to deliberate on this? Okay, could I entertain a motion?
I'll make a motion that we approve the request for agency action to release the bond for the Emerald Green Mine to the division.
And I'll second that.
Motion's been made and seconded to approve the request for agency action as requested. All those in favor say aye.
Aye.
Any opposed say nay. Okay, motion is unanimous. Mr. White, you want to go ahead and admit these exhibits and provide us a draft?
Yeah, I'll prepare the draft order. Thank you.
Okay. Thank you. We'll move on to the next item. Okay, so let's take appearances for, oh, I better read it into the record first. Sorry. Yeah, where'd mine go? Yeah. Okay, item number 2 is docket number 2026-017, cause number M0530059. In the matter of the notice of agency action wherein the Utah Division of Oil, Gas, and Mining requests the board issue an order forfeiting the bond covering the Limestone Mesa Desert Bronze Quarry, permit number M0530059, S40, Township 41 South, Range 12 West, SLMB in Washington County, Utah, authorizing the division to reclaim associated surface impacts from the operator, Southwest Stone Incorporated, and authorize the division to take any and all additional actions necessary to recover insufficient funds of reclaiming the mine. Let's take appearances for the division.
Thank you, Chairman Walker and members of the board. Assistant Attorney General Gary White, here on behalf of the Division of Oil, Gas, and Mining. And similar to the last proceeding, I have Division Expert Kim Coburn with me. I would note for the board that there is an individual here associated with this mine. I don't know if he'd like to come up, but there is a representative of the operator here.
Okay.
I also need to disclose to the board that yesterday I received a message from this individual. It's Mr. Sagers.
Mr. Seger is the operator.
Yeah, I received a call from Mr. Sagers asking me somewhat informally if the matter could be continued. I told him that I wasn't aware of any motion before the board. He then disclosed to me that he had counsel, and as soon as I found out he had counsel, I asked that his counsel contact me. I received a call after hours last night from counsel. He left me a message and stated that he didn't know much about the situation, that he had received some documents. I tried to contact counsel again this morning before the board hearing, but was not able to connect with him. So I don't know what the board would like to do with that. The division is prepared to go forward today and would like to go forward. However, I wanted to disclose that I received a call. I've not been able to connect with counsel. I don't know what the request necessarily would be. So I just wanted to provide that information in full disclosure.
Okay. Let's go off the record for a second. I think we want to continue to proceed with this, but I'd also like to ask Mr. Sagers, is it, to, if he could step up to the mic so we could, I think, ask a few questions, because if we're thinking about doing a continuation, I'd like to understand why we hadn't proceeded before this. So,
Chairman Walker, just for the record, I don't have any objection to Mr. Sagers, stating his concerns about the proceeding. I would note that this operator is actually a corporation and is required to be represented by counsel. However, I just want him to lodge that for the record, but I don't have any concerns about him stating what he's here today for.
yeah. Yeah, so let's, before we have the division make a presentation, let's go ahead and I'd like to understand if Mr. Sagers received notice in time, if he had time to respond, why, this is been on the docket for about 45 days at this point in time, so I just want to be clear as to why we're at this point where we're scrambling to try to get a hold of council. So if you could let us know what's going on there.
Okay. Now you're on the mic. All right, sorry about, yeah, I have to deal with my voice, I'm sorry. Yes, we did get notice, and I've got other operations that we've been quite busy with. I went the first week of January and met with Jason West at the BLM about the situation. He said they didn't want to continue anything because they want to put a campground where we're at. It's all flattened out. We just have stone inventory that's been there for a lot of years. Stone cycle for homes and everything goes like that since 2011. It's been all grays and dark colors. So we've had our brown material down there that's hardly moved at all. The perfect storm is the last 5 years since we entered this last agreement with the BLM.
Not evident.
I work on a visa program, and we have struggled for years to get our visas for the last 5 years especially, because we've been put in a lottery system with everybody else. Before that, we used to have what's called a returning worker exemption.
Okay, really what I want to understand is why you're not represented by council today, because we have a process that we have to follow.
I've tried to reach him for weeks. Haven't had a return call. His name is V. Lowry Snow. He's a state senator from Washington County. And anyway, he finally returned my call Monday, and he said he's had some serious family problems and has been mainly out of the office. And so Monday he said, please send me everything. And then Tuesday he had a surgery yesterday. And so we talked briefly in the afternoon, and he says, I'm in rough shape. I can't fly up tomorrow. See if you can talk to somebody and get this matter postponed. And so that's when I called Mr. White. And subsequently, it was like, 2 hours after I talked to Lowry. And when I tried to reach him back, I had no answer. I'm guessing he was probably knocked out. But I thought you had talked to him this morning. You told me no.
I tried to contact Mr. Snow this morning, and we did not connect.
Oh, okay. My misunderstanding.
No, it's okay.
But that's the reason I'm not. And
Okay.
so.
Okay, Mr. White, what is your suggestion on what we ought to be doing here?
Well, the division's perspective is that this is this has been a long matter, as you'll see if we go forward with the presentation. It's been going on for years. This was properly noticed. I think procedurally what should have happened here was an appearance of council and a motion to continue.
Yeah.
However, I am sensitive to the fact that apparently council's had some health and family issues, but I'm just not really prepared to speak to that today. Due process is important, but I think due process has been served here through the notice and the requirements of the rules which the division met when filing and serving this notice of agency action. So it would be the division's perspective that we go forward. However, I understand if there's other concerns from the board.
Okay, I think we need to proceed with due process. So what I'd like to do is go ahead and let's hear the division's presentation. Mr. Sagers is not represented by council, so I think we can take his comments informally, and then we'll decide what to do. We may actually have to take a period to deliberate on this a little bit. Go ahead, Mr. White.
Thank you, Chairman Walker. So the limestone mesa mine, pictured here, as Mr. Sagers has already represented, there are numerous pallets of the mined rock. I think to the tune of about 1,200.
1,700 pallets.
1,700 pallets. on the mine site. And as you can also see from this picture, there are some invasive weeds that are part of the reclamation that we'll request today. I'll ask Ms. Coburn to describe where this mine is and what this image shows.
So this image is the current area of the permit. A lot of it has already been reclaimed, over half of it. What's left is, as Mr. Sager previously described, is a flat area on top of all the mined out material. What we're really concerned with is the 6.8 acres of the active disturbance that's on BLM, along with the 0.6 acres of road. That's what we're here today to discuss on the BLM.
And then and Ms. Coburn can describe what this shows.
So this is one of the images that we have in our file from when he was doing reclamation with the different areas. This is kind of tilted on its side. Mr. Sagers has mined out material, reclaimed as he went. So this is showing as he was going through the different areas reclaiming. And we're mainly concerned with the main stockpile area that has been left, just to the bottom of number 3.
So,
Can you hold on a second there?
oh yeah, for
Can
sure.
you go back to that photo? Okay, so all those things that are lined up, that's material that they've already quarried, and it's on pallets at this point in time.
Out loud.
Yes, this is areas that have been quarried. The mine itself has been reclaimed and stabilized, and we're mainly concerned with the pallets and the staging areas that are left.
Okay, thank you.
So, some background facts here. Limestone Mesa Mine is located on BLM property in Washington County, and the actual operator is not Mr. Sagers. It's a business entity, a corporate entity, Southwest Stone Incorporated. The division understands that this operator was seeking building stone at the site, as you saw pictured in those pallets. There are 2 bonds at issue here. The division has a cash bond with the Utah State Treasurer of $33,600, and the BLM also has a cash bond of $11,600. And as we'll show in later slides, the operator lost access to this site because of some instructions from the BLM December 31st, 2025. So we'll walk through what happened there. This operator had a sales contract with the BLM which expired in 2019. Apparently, pursuant to that contract, the operator was to pay $11,500 to BLM. To the division's knowledge, only $345 of that sales contract was paid, meaning that this operator owes a balance to BLM of $11,155. Because of those deficiencies, in July of 2019, the BLM recommended that the site be fully reclaimed. Following up on that, in June of 2020, the division sent this operator an inquiry regarding the status of the mine after inspecting the site and determining that no reclamation had been completed. A few weeks later, the operator responded, stating that, quote, "the seam in which we were mining fizzled out," end quote. So the division understood that the life of this mine had ended. And then in August of 2020, the division ordered that this operator complete reclamation as outlined in the following table. The division gave this operator until December 2023 to finish this work. As you can see from this table, there were various phases that the division ordered this operator go through to remove the pallets at the site. So for example, by December 31st of 2020, 150 of these pallets were to be removed. And then as you go down, by December 31st of 2023, all of the pallets were to be removed and final reclamation was to be completed. A reclamation extension was granted in 2023 because the work remained undone. And in August of 2023, the BLM granted an extension through December 31st of 2025, and we have that signed extension pictured there on this slide. The operator originally had requested 5 years from 2020, seeking to complete this by 2025, which, as you can see, both the division and the BLM eventually granted that extension request. Unfortunately, a January 6, 2026 inspection by the BLM determined that no reclamation activity had actually taken place despite the extensions and the orders from the division. That inspection also revealed that this mine site appeared to be completely abandoned. Similar to the prior proceeding before the board, the same applicable law applies here under Utah Code Annotated Section 40-8-14, where an operator fails or refuses to perform reclamation. The board may declare that surety forfeited. And under the administrative rules, the board is also able to forfeit these sureties so that the division can complete the work. So today the request would be that this board issue an order declaring that the operator has failed or refused to conduct reclamation. I know that Mr. Sager has already presented some reasoning why that was difficult, but nonetheless, it remains the case that despite orders and extensions, the work has not been done. The division would ask that the bond be forfeited to the division so that in conjunction with the BLM, the pallets can be removed and the weeds can be removed and the site be fully reclaimed. And that would be our presentation, Chairman Walker. I don't know if the board has questions for the division or would like to talk to Mr. Sager.
Let's take questions to the division first. Go ahead. Oh.
Are you ready for board questions?
Yeah, go ahead. Sorry.
So you guys have a $33,000 bond. The
Correct.
feds have $11,600. However, they are owed $11,155 for unpaid receipts.
So this money is only for reclamation. It cannot be used to pay the contracts and things like that.
Okay.
Unless we have operator permission and other things. This money is only to be used for reclamation.
The BLM bond is only to be used for reclamation?
That's my understanding as well, unless Mr. Segers, as part of Southwest Stone Inc., authorizes them to be able to use it.
Are you going to request the BLM give you that money to put towards reclamation? How does that work?
So right now, the BLM has requested of us informally to go through the forfeiture process and transfer the money over to them to conduct reclamation. So
Okay.
we're going to transfer it all over to them, who would then, it's my understanding that, as Mr. Segers said about the campground, to be the final post-mining land use.
And
They-
so your money is going to the BLM, the
Yes.
$33,000. And then the BLM owns that all those pallets that can be sold. Is that?
I
since they
think-
are mineral owner.
I anticipated that question, Ms. Garrison, and I think that would be an issue between BLM and this operator. What takes place with those pallets and the materials. You know, as outlined in the presentation, there is a deficiency in payment of the sales contract, but the division will take no position on ownership of the pallets.
And so beyond your bond amount, does the division have any further liability for reclamation beyond that $33,000?
When you say liability, do we anticipate it'll cost more than the $33,000?
Right. Do you have to go in and do anything since it's BLM land?
It's my understanding that we're not requesting any additional funds at this time, and that part of this last request for civil penalties, there have been no civil penalties against Mr. Segers. We haven't brought anything. I don't anticipate us bringing anything against Mr. Segers on this at all. We're just asking for permission if there's additional ones in the future. Right now, I anticipate the money to be able to be used just for his mine site itself and the road access to it to help stabilize it. There's been a lot of washouts and floods in that area.
Thank you.
Yeah, I have one question. Is there a value associated with the 1,700 pallets?
Mr. Segers knows the value a lot better than us, and he actually has some figures that he has.
Can you share that with us, Mr. Segers?
Certainly. So most of what we've had down there has been sold. Well, it's been sold in 3 categories over the years until the colors weren't popular and everybody was going to grays and dark colors on their homes and everything. But yeah, contractor pricing with the pallets and the different categories of what they are, which material and how much each material is. $1,035,770 on contractor. Wholesale is $828,000 and $828,616, and a retail price $1,657,232.
I'd again just like to emphasize from the division's perspective the value of the material on those pallets and ownership. That is not an issue that the division, we're not seeking ownership of that. We're just seeking to have it removed as part of the reclamation. Where it goes, that will not be something that we are concerned about.
And so does our order authorize you to forfeit the $33,000 bond and transfer it to the BLM for reclamation?
Your order will, assuming you grant this request, the order would allow the division to conduct reclamation, and then the division will use those funds in conjunction with BLM to ensure that the reclamation is completed.
Okay, thank you.
So, Mr. Sagers, why didn't you move them if there's that value there, and ensure that you keep them?
First thing, you got to have a market to move them into, and when that stuff isn't moving, that's a big problem.
So even to move them onto your own property, just the value wasn't there at the time.
Adjacent, we were a big operator down there from 2000 on, and I've got another 6 acres of private land that I have across the way that we mined off a different area down there, not this particular site. And most of that rock is sitting on private ground over behind there.
Okay.
So the other big problem, I had a company that was willing to come down at a discount and take a lot of that inventory, but they had the same problem I had. They didn't have the personnel, because my kids aren't going to go down there and stack pallets, and your kids won't go stack them. I've been through 100 local kids that, they're gone before lunch the first day when it comes to this type of work. We haven't been able to get the visas that we've needed, for the last 5 years. We've been shorted, and they've had the same problem over at American Stone. They haven't had the people they could let go to send down there, because a lot of that has to be repalletized.
Okay.
Yeah.
Yeah, I have a question for division. I'm having a hard time understanding the relationship between the division and BLM regarding to the bonds and the reclamation. So if the BLM has made a comment they want to have these lands adjusted, prepared for a campground or something, what has that got to do with the reclamation? Division evidently is responsible for reclamation. And then is the BLM the people that say that it's adequately reclaimed, or is the division making that decision?
So on this, like the previous matter with Sitla for the stable post-mining land use, Sitla's using that area for being grazing. On this case, the reclamation of the land would include removing all the pallets, making sure that all the weeds are taken care of. But in this case, they're not going to reseed. They want to make it, they were talking about using some of the material that was there on site to crush it up and make it a nice flat area that's gravel, so that they could just make for the campground sites. So that will help them to have a stable post-mining land use. And that's what the division's rules are for reclamation, to make sure the mine life has something stable afterwards. So they have other funds for the campground that they're going to be using for doing this project. For doing any of the actual facilities. What we're mainly concerned about is making sure that the land after mining is stabilized.
So let me ask you again. Now, the pallets will be removed first, either by the mine or the BLM, and then the reclamation is done with what's left. I don't understand the order of how things are going to happen.
So a lot of this with the order is there's a lot of weeds on site, and in order to treat the weeds, such as being described previously with Sitlove, with being able to use the ATVs to go and spread them and harrow and things like that, that kind of treatment, we have to move the pallets out of the way first. So that's why the pallets would be coming off site.
Deputy Director Dean would like to discuss the concept of the post-mining land use as it relates to this mine.
Thank you.
Is that okay?
Yeah.
And our relationship with the BLM.
Yes.
So, we are the lead agency with the bonding and the permitting, and every mine has to have a post-mining land use, and we have to make sure that the reclamation is done to that standard. So what Kim's trying to say is there will be actually a little bit less reclamation done. We don't have to seed for this post-mining land use. So that's all she's trying to say is because of the campground, there's a little bit less reclamation that will be done because the BLM is going to build a campground. They're not using our $33,000 to build the campground. They're using it to stabilize the site and make sure that it's ready for that campground. But we won't have to go in and make sure that there's seeding done and regrowth of vegetation. Now that would be we do that for other post-mining land uses such as wildlife and grazing. But when you're doing a campground or an industrial post-mining land use, then you don't have to do that seeding and make sure that the growth of vegetation comes back. So depending on the post-mining land use, you'll have some different reclamation requirements. And that's all she was trying to say with the campground is we're going to do some different things for reclamation. We still need to make sure everything's stable, but we're not going to worry about a seed mix and how this grows back and weeds and things like that because they're going to build a campground here. So we just are going to put some gravel instead of seeds.
Does the BLM want that access road left if they're going to build a campground?
That's Kim.
That's my understanding is that they want it left.
Okay.
I could share my screen with some of the road is really rutted out right now.
And they'll take care of any corrective action on the road, is that right?
Exactly. That's what I expect a lot of the funds to be used for is to help stabilize that access road into there. So right now on my screen, I'm not sure if it's being shared. There it goes.
Can I say one more thing, Kim?
Yeah.
And these two cases, you're seeing us with these small bonds, and most of the reclamation work is done, and so we're giving the money to the land owning agency. If this were a mine that had not had if these mines hadn't had most of the reclamation done, we would likely keep the money and do the work ourselves. We're in conjunction with the land owning agency. But in both of these cases, most of the work has been done and there are small things left. And that's why we're transferring the money over to those land owning agencies to just take care of the small things that are done. And these pallets are a weird mineral owner thing that we don't want to be involved in. It's between the BLM and the lessee or whatever. And so that's why we're transferring the money to Trust Lands and to BLM in these two cases. If these were mines that had, shut down their equipment, open pits, we would be doing the majority of the work ourselves. We wouldn't be transferring the money over to the land owning agency, and they appreciate when we do that. But in these two cases, it's a little bit different because most of the reclamation work has been done, and they're just smaller things to take care of. So that's why these two cases are a little bit different than usual.
Before we look at that, so I think I'm starting to understand the relationship between the BLM, between various agencies. You look at them as a landowner.
Yes, they're the landowner.
They're the landowner.
Yes.
So
we're still the regulator. They're the landowner.
Yeah, you regulate even though it's federal land, but
right.
Independent of federal land, they're a landowner.
Right.
So that's why then if there wasn't sufficient bonding, then the Doggin would have to pay for the.
It depends.
Well, under the statute and the rules, Doggin actually is allowed to seek additional monies from the operator or its principals. it doesn't necessarily have to come from Dogham's coffers.
Right.
Fortunately, Dogham usually has full cost bonding, so it's not an issue that arises often. But there are avenues in district court if there's an underbonded situation.
Right, and we've done that before, and I think BLM also can go after similarly, and they've done that as well. And we've cooperated before when we haven't had enough money. We've both put money into it, and so we're both, all agencies, trust lands, us, BLM. Our goal is to protect the land that's within our borders of the state of Utah. We work really well together to make sure that these mines are operating properly in the first place, that they're fully bonded. The only problems we've ever had are when people mine outside their permit areas, and we've had fewer and fewer of those. But it's a cooperative effort, but we are the lead agency in all of these situations. And like I said, we usually do the reclamation, but these are in these cases, most of the reclamation has been done. So that's why we're transferring the money to the other agencies.
Yeah, so if it's at $2,000 an acre, if it's typically like that for, so it looks like funding's in fairly good shape as far as
Exactly. There's a lot of things with these pallets, such as Mr. Segers described as they've been out in the elements since about 2008. And so a lot of the wood has broken down underneath the pallets. And a lot of the pallets are really heavy and require heavy machinery to move them off site.
All right, so if we approve your request for agency action, then the funds will go over there, and it will actually be between the BLM and the operator as to what to do on their land with the material that was mined. And
Correct.
Division is out of it, and they only have one party to deal with, as I understand. Is that correct?
That sounds correct, yes.
Okay. Yeah. Okay. Anything else, Mr. White?
I just have some housekeeping. Similar to the last matter, the information that was outlined in the presentation is taken from our exhibits. There are 10 exhibits that we submitted to the board in this matter.
Yep.
As you'll see there, these exhibits go over things like the notice of intent, the notice of intention, the orders that came from the division, and the BLM's inspection is also there. So we would move that the exhibits be admitted and be part of the formal record.
Okay. All right, so done. Or do we want to do any deliberation, or do you have any questions of either the division or the operator at this point? Okay. Leaning on my mining guys here, what we should do.
I think we can move forward.
Okay, go ahead. So we'll entertain a motion.
I entertain a motion. I make a motion to move forward with the agency's request.
Okay. Is there a second?
Second.
Okay. Motion's been made and seconded to approve the division's request for agency action. All those in favor say aye.
Aye.
All those opposed say nay. Let it reflect it's unanimous. Mr. White, if you can draft the order, and we will let's take a 10-minute recess, and then we'll reconvene at, let's reconvene at 10:45 by this clock, and we'll take up the bonding issue.
Thank you.
Thank you.
One.
Thank you and welcome back. We're back on the record, and at this point we're going to take on the oil and gas bonding rulemaking comment period. That's been requested by other parties, and given that we only had 2 requests for agency action, we thought this would be a convenient time to do this. So the order that I have at this point in time, we've had a couple of requests during the recess and a couple of additions. So the division didn't ask to make comments, but I told them to make comments. So they're going to make comments first. Then we'll go to Holly Hill, Drew Levine, Fred McDonald, Spencer Kimball, Ricky Renko, Browning, Matt Lepore, Lauren Beatty. We have not identified anyone from the Western Leaders Network that's going to participate, but we'll wait and see when that time comes if someone appears. Then Tyler Work and Soren Simonson. That's the order that I have at this point in time. It's the order that things were requested, and with one change. Now, what's obvious to me is the last request for agency action took a little longer than the 10 or 15 minutes we thought it was going to take. So we will probably take a lunch break around noon, depending on where we are. Again, we ask that talk about 10 or 15 minutes on what concerns you, and then we'll see if we can, then we will take a lunch break and we'll see how much is left to do after lunch. With that, Mr. Thomas.
Chairman, thank you for the time. I'm going to speak briefly to our latest draft. Next to me is Megan Crocker, who is, if you have any questions, she's happy to answer them. Megan has led out in the more granular details of these bonding rules as we've worked through it. We appreciate her help. You may recall that we actually had a comment period a month or 2 ago, and as a result of those comments, the division found what was considered technically substantive changes. There was some ambiguity in the rule that was more than simply moving a period or dotting an I or something, and legally that qualifies as substantive changes. And so we asked the board, and you granted the ability to pull it back off, make those corrections for clarity, and then open up a new comment period for that. That comment period started on March 15th and will go until April 30th. That's why the comments are, and testimony or whatever it's called, the comments today fit in that window. The draft is posted with the clarifying corrections made. As of this morning, the new bonding calculator is also posted so that parties can go in, enter their data, manipulate, see where it comes out. And I'd say that's where we are right now. I think it's worth noting, again, Chairman, members of the board, it's not a one-and-done comment. An operator or any stakeholder can make comments throughout this comment period. They'll have some statements today, I'm sure. They may have additional comments that they could provide to the division, which serves as your administrative arm. They could provide those to the division up until and including April 30th. So a robust comment period is very good. We're still within the 6-month rulemaking window. I think we're doing very well time-wise. So I just want to let you know what the calendar was looking like there, and we're happy to invite any questions you have, or we can initiate the comments.
Okay, so we are now in our first or second comment period? Second comment period. Okay, all right. That's not too bad.
No, it's good.
Okay. All right. All right. Any further comments? Megan, did you want to make any comments before we open it up to the general public?
Megan's solid.
Okay. All right.
Thank
you.
you.
Let's go ahead and proceed then. Holly Hill, if you could please come forward, identify yourself and the agency that you're working with. Yeah, sure. Take your time.
So I have them doing a timer. So
Okay. Good morning, Chairman Walker and board members. I'm Holly Hill with Fielding Hill, and I'm here today on behalf of Greylock and Coda as the two largest producers of natural gas in the state, with over half of the natural gas production coming from these two companies. Here today also with us is Drew Lavage with Coda, so we'll get to him in a second.
And Drew, I apologize for butchering your name.
That's okay.
Sorry,
It's Lavage.
I'm also butchering it.
It's a hard one.
Okay, I've heard three different ones this morning, so okay. And how would you like it, Drew?
Lavage,
Lavage.
like savage, but with an L.
Okay.
Perfect, thank you. So first and foremost, we want to recognize this long process that we've endeavored. This has been a long 6-year process with robust stakeholder engagement, and we've appreciated every moment that we've been able to connect with staff. They've been very helpful. And I think across the board, everyone agrees that Dogum needs to increase their bonding. So I think that's a positive note. Our position right now that we're going to go over, and Drew's going to get into some examples and explain how we're interpreting the draft, but we support the March 17th draft language. We have one request. We want to see the calculator updated to how we're understanding the draft language, and I understand that there is a new calculator up today, but we haven't had the chance to run it. So we're asking the board to direct the staff to update the bonding calculator to match this draft if it hasn't already been. And I'm going to hand it over to Drew to continue.
Yeah, just for.
And just a second, Drew, if you would. And just for the division, I'm going to ask you guys at the end that make sure that we have resolved these any misunderstandings. So be prepared to come back up later on, if you could, please. Thank you. Go ahead, Drew.
Thank you. So just for some background, the rule as it sits today already has tier qualifications that screen for financial health, which we agree with. So right now, today I think we're going to talk about blanket bonding and then supplemental bonding. So right now the qualifications required for blanket bonding have two components. So one is an operator's production level, and the second is a threshold of at-risk well ratio. And so for tier 1, it's 1,000 BOE for the previously reported 12-month period, and an at-risk well ratio of equal to or less than 20%. Tier 2 is 500 BOE and 22%, and then tier 3 is 200 BOE and 25%. This is why we feel like that at-risk well ratio definition really matters. And so to be clear, how the rule right now defines at-risk well ratio, it's an operator's total number of at-risk, which it explicitly defines as at-risk state wells, divided by the total well count of an operator, including federal wells. So important here that we're using total well count as the denominator. We feel like this incorporates an operator's overall portfolio size, not just their at-risk well count. And that's already embedded in the rule's own risk measurement that goes to your tier qualifications. And we feel like the supplemental bond exemption should reflect that same logic. As has already been stated today, we felt like the November draft created some ambiguity in interpretation. And so the language of that draft, which was carried through until the most recent draft published March 17th, was for the supplemental bond for each tier, the allowable percentage of at-risk wells exempt from inclusion is as follows. Tier 1, 20%, Tier 2, 13%, and Tier 3, 8%. And so just to go through some interpretations here using a hypothetical operator example, if you have an operator that's Tier 1, meaning it's already been identified as the lowest of the risk financially, with 2,000 total wells, 200 state wells, and 20 at-risk wells, that would be an at-risk well ratio as defined by the language of 1%, so very minimal risk there. We interpreted this language here on the slide to mean 20% of total well count just again using the same definitions that had been expressed in the tier qualifications, which would mean that for this operator, there would be 400 wells exempt from supplemental bonding that could be included in an operator's blanket bond. So there would be no supplemental bonding required for this operator. Their total bond would be $650,000. The way that the calculator that was published also in November worked was taking 20% of just the operator's at-risk wells, which would mean that there were only 4 wells exempt, which would mean that 16 are not exempt. The rules have that round down to 10, and so supplemental bonding would be triggered, which would cause a 50% increase in their bonding obligation. Again, 2,000 wells, 200 state wells. It's a tier 1 low-risk operator with only 20 at-risk wells. Their total bond obligation would jump to $975,000. We feel like the draft that was published March 17th resolved this ambiguity. We agree with the draft language. So that first bullet point was the existing draft language that was published in November and carried through to February 24th. I'm not going to repeat it. It's the exact same as we had just walked through on the previous slide. But the March 17th draft language that we were told will be posted to the Utah State Bulletin April 1st explicitly states that for each tier, the allowable number of at-risk wells exempt from inclusion in the at-risk well supplemental amount is as follows. So now we're being specific that tier 1 operators get 20% of their state wells exempt from supplemental bonding. Tier 2 is 13% of state wells, and Tier 3 is 8% of state wells. And then we put in here the definition of state wells from the rule itself. I'm not going to read the whole thing, but state well meaning that any well located in Utah either penetrates or proposes to penetrate fee or state minerals, or is a well that is not otherwise subject to a performance bond with a federal, tribal, or other government agency having jurisdiction. We feel like that language clarifies the ambiguity, and here is how we feel like that language works in practice. So for the same hypothetical operator that's tier 1 with 2,000 total wells, 200 state wells, we're saying the rule is saying that 20% of their state wells are exempt. We read that as 40 of the wells. But I want to walk through 2 different scenarios with y'all. One where we feel like there's no supplemental bonding triggered, and then one where there would be supplemental bonding triggered for this operator. So the first scenario is the same 20 at-risk wells, which is an at-risk well ratio of 1. They get 40 wells exempt from supplemental bonding included in their blanket bond of $650,000. If this operator with 200 state wells now had 52 at-risk wells, meaning their at-risk well ratio, which is how we've already defined their financial risk to the state, increases from 1% to 2.65%, they would still get the 40 wells exempt, but any wells above that would trigger the supplemental bonding. So for here, you'd have 12 wells that would not be exempt. That would round down to 10. And then that would trigger the additional bonding, bringing their total bond to $975,000. And we feel like that's reasonable. That math scales with what we feel like is an operator's risk to the state. And then again, as we were aware last night, at least that the bonding calculator that we had access to had not been updated since the November draft. Obviously, if it has been posted this morning, we haven't seen that, and we look forward to running that calculator.
Thank you, Drew. So as mentioned, our request to the board is to direct staff to update the bonding calculator before finalization to match with the draft language. Again, we look forward to running that. We do like the March 17th draft. We believe it's very clear. And then updates that exemption denominator, as Drew has pointed out, to actually pair with the operator's financial risk in the state. If the directive is confirmed, we withdraw any objection to the rule as drafted, and we support timely finalization and implementation of this rule. and we would request to reserve any remaining time for rebuttal if necessary.
Mr. Walker, your mic is muted, so we're not hearing you.
Sorry. Okay, sounds like there are no questions by the board, and so no rebuttals are required. The bonding calculator was just published last night, so we totally understand that you have to have an opportunity to review that. And it's helpful that you run your scenarios because, you know, the board has, or the division has its targets, and then you have your particular things you're worried about. So, okay.
Thank y'all very much.
Thank you. Okay, so that takes care of the first two appearances that I had. So the next appearance would be Mr. McDonald from Lair and Lair.
Thank you, Mr. Chair. If you just give me a second to get my computer
Certainly.
set up. Switch the plug on that.
I wanted to make sure both tables have access to it for you.
Okay, Mr. McDonald, if you could please identify yourself and who you're representing today.
Yes, Fred McDonald of Council with Lear and Lear on behalf of the Utah Petroleum Association. I'll be tag teaming with Ms. Renko Browning. My position today is to advise the board of the red line versions to the last draft that was submitted by the division. A little surprised to find out that the calculator was changed again. But we'll go through these responses, and I think you've heard a lot of these before. So we're going to reiterate these same points. To start off with, and this has been the biggest problem with us, is the inclusion of shut-in and temporary abandoned wells as part of the at-risk situation. As you've heard from the initial draft that the division submitted back when, several years ago, the Utah Petroleum Association has taken a position that the shut-in and temporary abandoned wells that are approved through the process and the current regulations do not pose a risk that requires additional bonding. As you recall, the situation is that after you have a year for a shut-in temporary abandoned, then they have to submit a application for approval to the division showing well integrity and that it does not pose a risk to the public. And they have to do that annually up to a point of 5 years. And at 5 years, they have to plug and abandon the well. And so there is a mechanism easily in place already that takes care of the division's supervision of this of these type of wells. And so the idea there is that the division always has the position to say, after this period, if the application is not sufficient, then they say you're not in approved status, and then that's when it comes into the situation of becoming an at-risk well. So the mechanism's in place, and again, I point out that this really hasn't been a problem in this state. Is because of that mechanism and because of the division's supervision, we haven't had a lot of problem with total abandonment and leaving it up to the state. So we feel that this is a very important issue for you to consider. And like I said, it's almost a situation with these shut-in temporary abandoned wells that it's a solution looking for a problem. So we would ask that, since this has gone on for so long, that, and we keep getting this and keep bringing it up and we're not getting any kind of movement from the division, we'd like to have the board at least state some position on that, or explain that if you're going to adopt the state's position or the division's position, that you explain to the operators the rationale for that, okay? And these are the changes. Again, this is simply taking the draft, and again, the division accepted the UPA's recommendation that they exempt out the drilling operations suspended conductor issue, but then this adds in the shut-in well, the inactive well, and the temporarily abandoned well that are approved in accordance with the regulation by the division. This is also the, as I just mentioned, that last time the division already adopted this concept of the drilling operations suspended concept and the need to exempt that out. The only concern here was to add this language about the 1 year has lapsed, or at least 1 year has lapsed, and that's to provide a gap or address a gap that we perceive that may exist between the drilling of a surface casing and the resumption of total drilling, depth drilling. Mr. Spencer Kimball will address that in his commentary a little bit more too, but there's an operational gap there that is of concern to the industry, and so we wanted to have that 1 year clarification in that definition. The next big issue was the Surface Owner Protection Act bonding amount, and we've talked about this before. And I think it's important to remember the current regulation provides that in the absence of a surface use agreement, and this only applies when there is a fee surface and a fee surface owner where there isn't a surface use agreement in place, okay, that the operator can get a APD approved by the division with reclamation standards and all that if they file a $6,000 bond. We all agreed that that's probably inadequate. The first draft that came out that from the division said, I believe it was 9,300, moving it up to 9,300 plus a per additional acre amount, which industry said, okay, yeah, we recognize that, that's okay. The next thing we know now in this latest draft is that it could be up to $100,000 for each well site. And that, we feel that's inappropriate under the circumstances and where this applies. Remember, the Surface Owner Protection Act does not supplant the accommodation doctrine where the mineral estate is dominant and you have to make accommodations for people. So the point is that you have the right to go on, you have to make reasonable use, and you have to reclaim, and there's standards for that. So what we proposed before, and we never got any response to it, and clearly it wasn't accepted in the last draft, was that in lieu of that, that you post a $100,000 statewide blanket bond. So you have it up to $10,000 per well on the land, and then you could have up to a $100,000 statewide blanket bond to cover any other situations, instead of each doing $100,000 with no criteria of what that's going to be between the $10,000 and the $100,000 of why it's justified. So we would ask that the board adopt this concept of having a blanket bond of up to $100,000 to cover that issue. This is a minor one. There was an issue here about when you have the double bonding, that you have the adequate to cover plugging and abandonment. The adequate was asserted at one point, We want to have that as a clarification to limit the amount least required to adequately, to address adequate plugging and abandonment. And we don't want to create disputes over what that amount should be. So it should be an adequate amount to cover plugging and abandonment instead of somebody claiming that it's, because there's always a dispute also about how much the cost of plugging and abandonment actually costs. So an adequate amount is a clarifying point. That's why we added that. That's kind of a minor point. On the performance bond adjustment, the division changed. We would request it before that it be every 5 years. The division changed it not to exceed 5 years. And we have members that have explained or expressed concerns over that, saying that it would be extremely inconvenient for the operators, and it would lead them all over to the map with bonding obligations regarding that. It makes it challenging for budgeting. It could be a $1 million bond one year and a $2 million bond the next. Knowing it's being reviewed every 5 years allows continuity and helping the operators plan operationally and financially and reduce the burden on the team that handles the bonding. So it's a practical situation. That's why they're requesting that it be changed, that it's a consistent 5-year review. We had requested this too with respect to modifications and adjustments of the supplemental bonds. The division obviously contacts the operator if the bond has to be increased based on the adjustments of the 10 wells up and down. But we also believe that it should be a reciprocal thing, that the division should also notify the operator of when there's an opportunity to reduce the bond. They're monitoring this, so it should be easy to do. And that's what we're requesting that as well. Yeah, sure. All right, then the final comment that I have here is the consistency in Tier 3 criteria. It appeared to me that there's an area in subsection 1A, Roman 4, when you're talking about the first definition of Tier 3 requirements and what qualifies, it's these first two elements. But then you go into the bond schedule itself, and they add this third element down there at the bottom. And so it's a question not so much of having deleted as making sure there's consistency in what the definition of the Tier 3 level is. And so that needs to be clarified. Again, I've shown it here as crossing out based on what the regulation or the criteria is defined up front versus what's in the schedule. So that's something else to point out here. With that, I will add again, it's been a long process. We again appreciate all the accommodations from the board, working with all the stakeholders as best we can, but we do have these issues still remaining. And again, based on whatever modifications occur or don't occur, you know, and depending how that shakes out in the bonding calculation, we may have additional comments to submit as written comments. Again, I do want to reemphasize that initial point I made about the shut-in temporary abandonment. It would really help if we get some direction of the board of what the position is on that or not, so we don't keep bringing it up and keep bringing it up or having the division deny it. We just need to get some direction on what the intent is of the board. With that, that concludes my comments.
And we'll ask the division to respond to all the comments at the end here, so,
Okay.
the ones that can. Okay, thank you, Mr. McDonald. And I understand next is Spencer Kimball, and is he electronic?
Yes.
Okay.
Good morning, Mr. Chairman. Can you hear me okay?
Yes, we can.
Yep. Stand by, Mr. Kimball. We'll get you put up in the room. Okay, we are good to proceed.
Okay, Mr. Kimball, can you please identify yourself and who you're representing today?
Yeah, good morning, Mr. Chairman, members of the board. My name is Spencer Kimball. I'm the Government Relations Manager for 4 Point Resources.
Okay.
And apologize, I'm unable to be there in person today, but I really appreciate you indulging my virtual statement. I presented at the last hearing on this draft rule in December, and I'd like to thank the board for the opportunity to present again today. 4 Point appreciates the time and effort that Director Thomas and the division staff have invested in working with stakeholders to meaningfully incorporate feedback. I'd also like to thank Ricky Urenco-Browning and Fred McDonald for their exceptional job representing the UPA in this rulemaking. By way of background, 4 Point operates a 126,000 acre position in the central Uinta Basin, which includes several hundred wells of varying production level and age. We support the division's goal to construct a rule that balances reasonable bond amounts while managing the risks associated with orphan wells. Overall, we believe that this draft rule accomplishes this goal, but offer 3 specific comments today. During the last hearing on this rule, I raised our concerns with the proposed definition of wells designated as, quote, drilling operations suspended, unquote. We greatly appreciate the division's response, particularly the added definition of drilling operations suspended conductor with wells in this category that are not included in the definition of at-risk wells. The last version of the draft rule included a time span for wells in the drilling operations suspended category, but that has since been removed. We recommend that the division add back to the definition a 1-year time frame before wells in this category are designated as at risk. There may be a gap, as Fred mentioned before, between the drilling of surface casing and the resumption of drilling to total depth, and a 1-year period would provide a sufficient yet reasonable amount of time between those activities and before the at-risk designation. UPA has suggested an edit, as Fred showed before, to implement this recommendation in the red line submitted to the division. We also request that temporarily shut-in wells not be considered at risk until after a determined time period in the final rule. Some wells may be shut in for sustained periods for many reasons, particularly if those wells are awaiting workovers to stimulate production. As many of the first horizontally drilled wells in the basin age, they become candidates for workovers to increase their productive life, but may ultimately be designated as shut in due to inactivity for 1 year or more, and therefore would be deemed at risk in this draft rule. As more of these older shut-in wells are awaiting workovers and they accumulate, supplementary bonds could escalate despite intentions to bring those wells back to production and prolong their life. DOGM data suggests that many wells are flipped back from shut-in to producing status within the first 1 to 2 years after being designated as shut-in. As such, we'd respectfully ask the board to not include shut-in wells in the definition of at-risk until after 1 or 2 years after the well has formally been designated as shut-in. Finally, there appears to be a disparity between the state well count figures in the online calculator and what we show in our internal records. Our count of wells that only penetrate fee and or state minerals per the definition of state well in the proposed rule is currently different than what is shown in the online calculator, which appears to list many wells that also penetrate federal, tribal, and or allotted minerals. This will not affect our overall at-risk well count, which appears to be limited to just those that penetrate only fee and or state minerals or our designated tier, but it will affect our blanket bond level within that respective tier. I do not believe that there is an issue between the interaction between the draft rule language and the calculator, just more an issue with how that specific portion of the online calculator populates specific well information by lease ownership. We will follow up with the division, staff, and the board on this concern. In closing, 4 Point is supportive of the proposed draft rule and will remain engaged with the board and division staff as it works to finalize and implement it. Thanks again for the opportunity to present here today, and I'm happy to take any questions you may have.
Okay, thank you. Anybody have any questions for Kimball at this time? Or Spencer, sorry. Okay, thank you, Mr. Kimball. I understand next is Ricky Urenco-Browning.
Thank you to the board. Ricky Urenco-Browning, president of the Utah Petroleum Association. I don't have a presentation, just some comments that I wanted to share today on the draft. I want to start by thanking the board, each and every one of you, the division and the staff. As everyone has said, this has been a very long 6-year process. And while I know that we are all eager to complete this process and move forward to address other needs that are stacking up, I do want to acknowledge that the board has demonstrated a significant amount of commitment to striking the right balance and finding a prudent path as opposed to just a fast path to get through this. And I think actually we all share the same goal, right? We are all trying to balance how, on the one hand, do we reduce risk to the state, ensure that operators are prudently bonded and responsible for their own well reclamation, versus, on the other hand, not unnecessarily tying up capital that should be deployed into reworking wells, drilling new wells, both of which lead to significant direct and indirect financial benefits to the state. I also want to recognize that there have been a number of tweaks in the rule compared to previous versions that have been addressed based on a number of comments from industry, and we sincerely appreciate that greater clarity and the balance that those changes have provided. I want to thank Mr. Now I can't say it correctly, Lavage and Ms. Hill, who just walked through that example. We hope that there is no longer any misinterpretation of the rule, and that we are all looking at the percent of state wells that are allowed to be included in a blanket bond for that at-risk category, as opposed to the percent of at-risk state wells. That change of interpretation makes a very significant impact for the operator, as was stated very clearly, and is something that we certainly support. Also appreciate the division updating the calculator. However, as you heard, we are a little bit worried if the current calculator is reflecting the language correctly. The calculator seems to now be picking up tribal wells in the state well count, which is not in line with the language in the text. Again, we will rerun that again with the version that was just posted. But it is going to be critically important that the calculator and the rule language are in fact synced and working appropriately, as you just heard from Mr. Kimball. You heard from Mr. McDonald as to each one of our outstanding concerns in the draft and why they are concerns. I don't want to belabor all of those points. I'm certainly happy to answer any questions you have on them. I do want to reinforce one that is really important to us and is the industry's largest current concern with the draft, and that is the treatment of all shut-in and temporarily abandoned wells as being treated as at risk. This has been a point of concern that UPA has raised consistently throughout the 6-year process. You also heard Mr. Kimball address this in the context of, we have a cohort of forced horizontal wells in the basin that are getting to an age where they are soon going to need to have workovers. So there is a concern that this could be a growing problem that is looming if those wells are shut in while awaiting workovers, if they are automatically treated as at risk and trigger a significant bond escalation when we are trying to direct dollars to reworking those wells and increase production, not tie up those dollars in bonding. As we've noted in the past, there are many reasons why an operator may shut in or temporarily abandon a well, or even a large swath of wells. So just bear with me while I paint the picture of another example. As you all know well, oil and gas are two of the most volatile commodities. As we started this discussion, not even a month ago, we were looking at tightening budgets and laying down rigs, to almost overnight now we're talking about how can we boost production as quickly as possible, and all because of price, and all because of the situation with Iran. And in this specific example, those prices have skyrocketed. But there have been in the past, think back to 2014, and there will be again in the future, other unexpected, swift circumstance changes outside of the control or influence of anyone in this room, outside of the influence of any of the operators, that swing prices in the opposite direction, where continuing production at the current level is no longer economically viable or a prudent use of the resource. And when those events happen, you're going to see operators shutting in wells, and not just one or two, but potentially many. More often, those price shocks are not long-lived. They correct. Wells are turned back on. We've seen this over and over again. And I'm sure we're going to see it again in the future. It's not an if scenario, but a when scenario. And so in this scenario where those wells are being shut in with a full plan and intent of bringing them back online when those prices stabilize, the operators are making that decision to ensure responsible and sustainable development. And I know I don't need to remind this board, but the statutory mandate of the board is in fact to promote responsible development of energy and mineral resources, prevent waste, and protect correlative rights. And that's exactly what operators are doing when they shut in those wells for economic reasons. And so we would ask the board to consider that as a duty to support those difficult decisions and not put in place policies that are counter to promoting responsible development and preventing waste. We believe that immediate treatment of all shut-in and temporarily abandoned wells as at risk is in fact counter to promoting responsible development and preventing waste. At the same time, we understand that the division believes the longer a well stays shut in or temporarily abandoned, the less likely it is to come back online. Division staff have presented data in the past that shows that nearly 60% of all wells that are shut in for less than 2 years are returned to production. 60%. And nearly 40% of those wells shut in for less than 3 years are returned to production. If that data is correct, it rather supports giving producers a certain grace period where wells can be shut in or temporarily abandoned with the expectation that they will be brought back online. As such, and as a compromise position, we would ask that the board consider a time period, perhaps a two-year time period, as Mr. Kimball noted, where a producer can shut in or temporarily abandon a well without it being immediately treated as at risk. If the well stays closed for a prolonged period of time beyond that time frame allowed, then the division could assign it to the at-risk category, supplemental bonding would be required, and that protection would be in place. It would seem the division is already structurally set up to accommodate that. Of course, this is from an outsider view. They may have a different opinion. There's already a time-limited system for wells to be shut in or temporarily abandoned without triggering supplemental bonds, as wells today are allowed to be shut in or TA'd for 1 year, and then with division approval and certain conditions being met, allowed up to an additional 5 years. As Mr. McDonald referenced. So this means the division is already closely tracking those wells and could grant a grace period before they are categorized as at risk. We would strongly request that the board consider such a proposal to allow those shut-in and temporarily abandoned wells a certain grace period, perhaps 2 years, before they are categorized as at risk and trigger supplemental bonding. We feel that provides the balance to give producers operational flexibility while not significantly increasing risk to the state. My final point in the comments that you've heard in the past have pointed back to the Colorado bonding rule, and I just wanted to share something. Some of you were at our annual meeting last week where we had a panel with several other state trades, and one statistic that was chilling to me that I heard was in 2021 in Colorado, they had around 250 orphaned wells. You'll remember that their financial assurance rulemaking was in 2022. Today, they have about 1,000 orphaned wells. I'm not going to say that the financial assurance bonding changes were solely responsible for that increase. I'm sure it's a combination of the more costly regulatory changes that Colorado has made overall, but certainly a very risk-averse financial assurance rule was a major component of that 300% increase in the growth in orphaned wells. So I want to be mindful that we move through this striking that correct balance and not actually creating the orphaned well problem that we are all trying to prevent, and the state of Utah luckily does not have today. I think most of us would agree that there's some hesitation in following in those footsteps from Colorado. So thank you again for listening to us, for giving us the time. I know that this has been a long process and that we all sincerely appreciate the time and attention that you've placed to it. Thank you.
I have a question. Okay, on the Colorado example, you said they had 200, was it orphan wells or temporarily abandoned wells, and then now they have 1,000 orphan?
250 and 1,000 is what my colleague
in both cases they were orphan wells?
That's what I was told. We can fact check.
If you could fact check that with those guys, that would be helpful.
Yeah.
And okay, and during your discussion at one point you said you'd like a 2-year shut-in period. At another time you said 5 years shut-in period. What is your bottom line there?
Yeah, fundamentally, as Mr. McDonald said, we don't think that shut-in or TA wells should be treated as at risk overall, just conceptually. But in order to try and meet in the middle, because we get the impression that there's some hesitation around that concept, I think the statistics from the division about the likelihood of wells being turned back in turned back on after 2 years is certainly very justifiable. I think 5 years would be appreciated. That's the time period that you're currently allowed to have an approved shut-in or temporarily abandoned well. So I leave that with the board. Obviously, a longer time period would give us more flexibility, but that's in your discretion.
Okay. Other questions? Go ahead.
So, just reading the definitions of shut-in versus temporarily abandoned. A shut-in well is one that's capable of producing, but is not for economic reasons or whatever. Temporarily abandoned is where there's not economic viability at that time. Shouldn't those be treated quite a bit differently? You're lumping them together and asking for, some more time on them before they enter the at-risk pool. But are they the same?
Yeah, that's a fair question. I think there's a lot of reasons why a well could be either shut in or temporarily abandoned. I gave the example of the economics. Mr. Kimball gave the example of those wells are being, set aside for workover. I think either way, to the best of my knowledge, there isn't a data set that would show that one is more likely to come back online than the other at a different time period. I don't think that we've teased out or tracked those metrics in a way that would allow us to disentangle that. If the division has that data, we would certainly be eager to hear it and try and work through what makes sense. But right now, from my understanding, is when we look at when a well is either shut in or temporarily abandoned, they're grouped together. And what is the time frame under which they're likely to be brought back on? So I don't know how we would disentangle those.
Okay. Yeah, temporarily abandoned just sounds a lot more at risk to me than shut in, because quite often you'll see a well shut in, say there's a frack nearby or whatever. Shut in sounds a lot more likely to come back on than temporarily abandoned, but I don't know. That would be helpful to know that.
I think maybe we'll ask the division to help us with that definition, because when I think of temporarily abandoned, they got bridge plugs in them or something like that, and they're not coming back. They're waiting to get P&A'd. So that would be a worthwhile discussion.
Yeah.
Thank you, Mr. Ranko.
Whoop.
Oh, sorry.
One more.
Sorry.
Remind me on the Colorado bonding rule, how does their rule differ from ours that caused them to go from 250 to 1,000? Is it similar in terms of the trajectory of where we're going with our draft bonding rules, or is that, how does that differ?
I think I would have to phone a friend, and you're lucky that you've got some folks that have been intimately familiar with the Colorado bonding rule here in the room that could speak to that. Again, I don't want to say that their financial assurance rule is the only reason that count has increased so dramatically. I'm sure there are many reasons, but I do think it is a cautionary tale that we should take a look at. I would proffer an assumption, without being intimately familiar with every detail of the Colorado bonding rule, that based on the interpretation that was walked through today of how our bonding rule is working as of today, that you just heard, that their rule is more conservatively stringent than that interpretation, if that helps.
Do they have the definition in terms of shut-in and temporary abandoned wells that would, there's someone back there that has the answer.
Yes. Phoning a friend.
Okay. Anybody else? Go ahead.
Yeah, and this is probably a division question, but while I'm thinking of it, as far as how often is the bond reviewed? Is there a certain time frame, and in conjunction with that, can an operator be underbonded to a certain degree?
So you're asking in Colorado how often?
No. I'm talking about Utah.
Well, in these draft rules, right now the red line says that it will be reviewed up to 5 years. So my interpretation of that is it could be 6 months, 2 years, 4 years, 5 years.
Yeah, that's right. I forgot about that one.
Yeah, so what we would like to see is a consistent time period so we know.
Yeah, right.
Was that all? Okay.
Anybody else? Okay.
Thank you.
Thank you. Okay, so next up would be Matt Lepore? There he is, okay. And thank you for coming all the way in. I have on my list that you're going to be electronically here, but nice to see you in person instead.
Thank you.
Thank you, Mr. Chairman. Am I on? Yep.
Yes, I think so.
Thank you, Mr. Chairman, and good morning, commissioners. As you can see, Lauren Beatty and I are going to tag team this a little bit and appreciate your time again today, the opportunity to address the bonding rule. I am happy to pitch in on some of the Colorado questions. I participated in the Colorado rulemaking on behalf of larger operators in the state, so I can tell you some off the top of my head, and others of it I would need to go back and check the rules. I'll tell you up front that the amount of Colorado bonding required is vastly larger than anything that you all are considering. Vastly larger.
Oops, I'm sorry. Can you help us with vastly? That's squishy.
Yeah.
Is that, I mean, are we twice as onerous? Are we half as onerous? 10% as onerous as Colorado? Not that I want to use Colorado as an example of a way to do business, but yeah.
No, it's okay. I mean, Colorado's rulemaking on financial assurance was lengthy, not as lengthy as this one, but lengthy and complicated and involved. I don't want to misquote numbers, so I'll tell you one that stands out. So there is a certain kind of bond available in Colorado referred to as the comprehensive bond, or option 6. So this is a one-stop shopping sort of bond for larger operators who don't want to fuss with all the administrative detail of keeping up year after year of what's producing and not producing, and low producing in Colorado is a thing somewhat similar to at risk. The amount of that bond is $40 million. So that covers you, and you can do what you want with your wells. So that's just one marker that I can identify for you without kind of digging into the rules. But on a rough guess, I would say we're talking rough guess 3x of what you're looking at.
Thank you. Mm-hmm. Okay.
So we wanted to start out with what's good about this regulation today, and it has a lot of elements from theory that we think are really good. We think good regulation should shield Utah's taxpayers from the financial burden of plugging orphan wells. It should have bonding amounts reflect the operator's true risk to the state. And lastly, it should provide incentives for operators to plug wells in a timely manner once they've reached the end of their productive life. So the current draft is a major improvement over current regulations. I showed this the last time I was here. On the left in orange, I've plotted fee state liabilities. So fee state liabilities and fee state at-risk liabilities. And then in green, I've plotted the sum of current bond amounts and the sum of bond amounts under the draft bond. And it looks like the draft bond approximately equals the potential liabilities of at-risk fee state wells. Here I've plotted...
Can I ask a question about that?
Yeah, of
first?
course.
Can you go back to that? Okay, so the first block of orange, that's if everybody walked away. Okay,
Yeah.
so that's
Yeah, it's
highly unlikely.
Highly
that would
unlikely.
ever happen. Okay.
All wells eventually need to be abandoned, though.
Sure. Okay. Yeah. Okay, thank you.
So here we've plotted fee state liabilities against the current bonding amounts, and what you can see is that, the vast majority of operators are paying a $120,000 blanket bond, regardless of whether, your risk to the state is potentially $20 million or potentially $10 million, or whether it's, say, $300,000. So it's not really scaling risk with the bonding amounts. And this is what the current draft looks like. And this is great because operators that don't meet a tier, and this we've called it tier 4, Their risk is approximately scaling with the bond amounts, and operators that pose less of a risk to the state, so operators that meet tier requirements, get substantial discounts. But we think that the current language in the draft is undermined by a couple really minute and key details that Matt will talk through.
So as you've already heard today, in part, an operator's blanket performance bond is determined by two elements, production volume and the at-risk ratio, the threshold there. This was very innovative. This was a great concept that ties the bonding to an operator's risk, and we appreciate that. However, as Lauren said, there have been some things that undermine that a little bit. So the definition of at-risk well ratio means the total number of at-risk divided by the total well count. That seems to make sense, but the definition of at-risk wells limits those to state wells only. So you're dividing state wells by all of the operator's other wells. So the numerator is small, the denominator is large. That has the effect of sort of diluting the operator's apparent risk. Think about it a different way. You're making an assumption that all of those federal wells are good producing wells, that none of them are at-risk wells or very low producing wells. So it makes sense to us for an operator to get credit for federal wells that are producing. That's their revenue stream. It doesn't make sense to give them credit for federal wells that are at-risk wells, that is less than 1 BOE average, because those are not, that's not revenue. That's a liability that they have to deal with. So we would like to see that numerator-denominator problem solved by the ways that are on my screen. Can you see the screen? Yeah, you can see the screen. Okay? Go ahead. Yeah. Yep.
Okay, I'm not sure I know what you want to do with the denominator.
Okay.
Well,
Well, I think there are two ways to look at it. One way is just do total wells and total wells. All the state's at-risk wells divided by the federal wells. A better way would be divide all of your wells that are less than 1 BOE by all wells that are greater than 1 BOE.
Our point is really that when you hear the phrase at-risk well ratio, you probably would think it either means at-risk state wells divided by all state wells, which is the proportion of the state's, the operator's state wells that are at risk, or you might think it means that it's total at-risk wells divided by all wells, which is the proportion of at-risk wells in the state. But they're using a small numerator and a large denominator. So just as an example at the bottom, you could imagine an operator with 1,000 wells in the state. If it had one at-risk state well and 999 at-risk federal wells, its calculated at-risk ratio would be 0.1%. And we don't think that that's a reflection of the true risk that hypothetical operator would pose to the state. If anything, it's more of a reflection of the proportion of state wells to the proportion of federal wells. So, and the next thing is supplemental bonds.
So, two issues here. The structure of the exemption for at-risk wells from the supplemental bond calculation, which you've, again, already heard a fair bit about. And then the second part is rounding down to the nearest 10. And then just to kind of refresh people's recollection, rounding down to the nearest 10 was the division's way of trying to level out the sort of fluctuation year to year in the numbers, again, the numbers of wells that come online and go offline or what have you. But the result of that now is, again, reducing the amount of supplemental bond that is being provided. So the March 17th draft rules that most people are commenting on here that have come out are fairly clear that the carve-out for supplemental bond is what is written. 20% of your total number of state wells, 13% for Tier 2, 8% for Tier 3. And then you, whatever that comes out to be, you round down. So let's go to the next slide. You can see here the big difference in taking the current rule, 20 at-risk wells divided into 100 wells gives you 20 exempt wells. In the prior iterations, it appeared that the calculation would have been 20% of those 20 at-risk wells, which means 4 wells would have been exempt. So the difference is a factor of 5, right? 20 wells exempt versus 4 wells exempt. Those, again, come out to pretty large differences in the amount of supplemental bonding that is to be provided. Go ahead.
Yeah, so now we just figured we'd walk through some examples.
Okay, well, hold on. We're going to have the division clarify that and make sure we all are on the same
Yes.
same interpretation of that. So just forewarning the division to be ready to clarify what
Yeah, so
what the intention is there.
Apologies. The latest draft we received is definitely interpretation 1. It says 20% of state wells. So we're going to sort of walk through some examples, assuming that that's correct. But I did download the calculator this morning, and it is still interpretation 2. So here's an actual example from my calculations of the state data. So this is an actual operator. They have 2,825 total wells in the state. 752 are at risk. 285 are state wells, and 38 wells are at-risk state wells. Now, this operator is going to qualify for Tier 1, even though 27% of its wells produce less than 1 BOE. You'll notice that the official at-risk ratio is 38 divided by 2,825, or 0.013. So they're going to qualify for Tier 1. And then the carve-out is going to allow them to have up to 66 at-risk state wells to be covered by the blanket bond. Why 66? Because you take 285, their number of state wells, multiply that by 0.2, and then the next 9 are essentially free because of the round-down rule. So this operator would owe 0 supplemental bond.
Yeah, and I just want to emphasize that this operator would have been a Tier 4 operator who would have had to have single well financial assurance for all of its wells without these changes. So he goes from no blanket bond allowed to blanket bond with no supplemental financial assurance whatsoever.
Thanks, Matt. Another operator. This operator has 49 total wells. 34 are at risk. 6 of them are state wells, and 5 are at-risk state wells. This operator qualifies for Tier 2, even though 69% of its wells produce less than 1 BOE per day. And the exemption or carve-out doesn't matter because there are less than 10 state wells to begin with. So again, this operator would owe 0 supplemental bond. And a final example, this operator has 608 wells, 112 at-risk wells, 87 state wells, and 19 at-risk state wells. They qualify for Tier 1. The carve-out allows for up to 17 at-risk state wells to be covered by the blanket bond, and the next 2 are free because of the round down. This operator would owe 0 supplemental bond. So, those are our 2 comments on sort of technical details in the language. We would prefer that the at-risk ratio be replaced to reflect true risk to the state. You could imagine if you were a lender trying to assess creditworthiness in a person, you wouldn't only care about their ratio of credit card debt to their total assets. You would care about their mortgage. You would care about their student loans. We think this is exactly the same thing. And the round down issue, I think this was initially put in because there was concern that bonds would adjust too much, but the solution is simple. Allow them to be fixed for a certain period of time and allow the operator to petition for an interim adjustment. So, yeah, you want to round out?
Yep, just to round it out, and I will like to address some of the earlier comments about whether shut-in or TA wells should be at risk. So let me come back to that. But we've identified 3 things we'd like you to look hard at. The numerator-denominator problem, which as it stands now artificially inflates an operator's tier. They go from tier 4 to tier 1, or tier 3 to tier 1 or 2, and it raises the orphan well liability risk. The new at-risk well exemption calculation undermines the risk tailoring function of the at-risk well supplemental bonding, and rounding down further reduces the amount of financial assurance available to manage and orphan wells. We have calculated that as currently formulated, no current operator will be required to provide supplemental at-risk well bonding, which is not where this rule started. That was not the intent. So, no current operator will be required to provide any supplemental bonding because of the way all of these calculations have been adjusted.
It's the combination of the exemption plus the rounding down rule.
And the tier level.
Just a quick question, though. Your original bar chart that showed we were very close to the at-risk covering it, that takes into account, well, that's the way it exists right now without the supplemental bonding.
Yeah, so
Because you're saying no one would have to have supplemental bonding, but we're still very close to our Fed fee state at-risk liabilities.
Yeah, I mean, I think, one, this picture hides a lot of heterogeneity across operators, so it's not really a complete picture. And yeah, we think that it's a vast improvement over the current draft.
I know that you have in the rule the 5-year review, and I think that's good and important. And it's not helpful that it's been, I think, 26 years now since the last upgrade, so I'm glad you're getting around to it. But I do think about future-proofing for this. And yes, you can modify the rules as you go, but I just encourage you to take a look at the things that we flagged and look at how that math works. And then if I may, and hopefully since there's 2 of us, we get more than just one 15-minute section. But with respect to whether shut-in or TA wells that are approved should be at risk or not, as much as industry has argued for their position, we have opposed that position all along for a few reasons. The first is that approval process does not consider the operator's economics in any way, shape, or form. There is no economic analysis happening in that approval process. It's looking at wellbore integrity, mechanical integrity. If that's in place, that's enough. So that is the first point. The second point is you create a loophole that will invite operators to put their wells into that program rather than plug and abandon them or return them to production. They're just allowed to be put on the shelf for 5 years and sit there and do nothing. The third point is we know that the longer a well is shut in or TA'd, non-productive, the less likely it is to ever return to production, meaningful production. So I hear there's maybe a 2-year window where that's less true. Still, 60% coming back within 2 years means 40% aren't. Likewise, 40% coming back on after 3 years means 60% aren't. So that opportunity for that loophole is important to us.
I'll add, like, that would make the rule deem, say, a well that's shut in to be less risky than a well that's producing 100 MCFs a month, which to me doesn't make very much sense.
Another point I'd like to make is that a well doesn't become inactive or shut in for 12 months. It can be doing nothing for 12 months before it's deemed inactive or shut in. So you really should start the clock then and not when it becomes that status, right? So if the industry wants a 2-year grace period, they're already getting a 1-year grace period. So
that was a question I was going to ask earlier. So when does that clock start counting? You're saying it doesn't start counting for 12 months.
yeah, and I'm happy to be corrected if I have that wrong, but my understanding is that by definition, a well is inactive after it's not produced for 12 months.
When do they have to apply for shut-in or TA?
I think 1 year after that.
Year after. Okay.
Yeah, and I'm sure that if I've misrepresented that, someone will correct me. If you're inclined in that direction, a thing that many states have done is require the operator to post a fee to keep it in that status over those 5 years. And that fee goes up year after year. So it's not doing what industry wants you not to do, which is not making it an at-risk well for which supplemental bonding is required, but it is putting a price on keeping it in that offline status and keeping it that risk of becoming an orphan going up year after year. You pay a price for that. So I'll just offer that as, something else to think about if you're inclined.
How would you determine the fee?
I don't know as well how things work here as Colorado. In Colorado, it would be a rulemaking. And you would say in year 1, it's X amount of money. In year 2, it's X and a half amount of money and so forth. But to me, you would work towards what the supplemental bonding amount would be, right? Ultimately, at the end of 5 years, you should be paying no less, or you should be paying what that supplemental bond amount would look like. Thank you very much for your time.
So I just got a note that the Soren guy, he had to leave
He
early,
left,
so
okay.
he's just gonna do a written comment later so you can scratch him off your list.
Okay. And so, okay, next on my list is Western Leaders Network. Is there anyone here from Western Leaders Network or anybody online from Western Leaders Network? No? Okay, seeing none. We've also had a cancellation by Soren Simonson from the Mormon Environmental Stewardship Alliance. So the only speaker we have left is Tyler Work. So is Tyler Work here? Or is Tyler Work?
Tyler's online.
Mr.
Chairman.
Sorry?
I'm online, Mr. Chairman.
Oh,
Can you hear
okay.
me?
Yes, I can.
Excellent. Apologize. Could you give me one moment to fix my video? Thank you.
Okay, thank you.
Good afternoon, committee members. My name is Tyler Work, and I'm a policy analyst at Taxpayers for Common Sense. Taxpayers for Common Sense is a nonpartisan budget watchdog founded in 1995 to ensure taxpayer dollars are spent wisely and transparently. For 3 decades, TCS has supported policies that safeguard the public purse, prevent wasteful subsidies, and promote fiscal accountability in natural resource management. As we have previously testified before the committee, TCS strongly supports Utah's efforts to modernize its bonding requirements. And today I'd like to reiterate the importance of maintaining key elements of the proposed update and identify opportunities to better protect taxpayers and communities. As you are aware, outdated bond amounts have left taxpayers exposed across the country. In Utah, current bond amounts are far below actual reclamation costs, as low as $1,500 for an individual well, even though average plugging costs are nearly 25 times that amount. And current blanket bonds as low as $15,000 can cover hundreds of wells at a fraction of their true costs. These gaps are not just a state problem, they reverberate at the federal level. And as the state's Orphan Well Fund approaches a zero balance, federal taxpayers are at increased risk of becoming a backstop for insufficient state bonding. Fortunately, this update offers an opportunity to close those gaps. The proposed updates will better hold operators accountable and protect state and federal taxpayers from escalating liabilities. Today, I would like to highlight 3 specific elements of the proposed update. First, while TCS opposes blanket bonds as insufficient taxpayer protection, we support the proposal to raise blanket bond minimums. The new amounts are moderate compared to actual reclamation costs and represent an important step towards ensuring operators, not taxpayers or the state's reserve fund, pay for cleanup. However, as has been previously discussed today, TCS has concerns with how the numerator and denominator are calculated for the at-risk well ratio. We advise the committee to include an operator's state, fee, and federal wells when calculating both an operator's production and the number of its at-risk wells to determine bond tier eligibility. We believe that operators should be able to rely on production revenue from all sources, just as the state should consider the potential plugging liability from an operator's full portfolio. Second, TCS supports creating supplemental bonds for inactive, shut-in, and other higher risk wells. Because these wells are already on the edge of becoming uneconomical, they must be properly bonded so operators cover the inevitable cleanup costs. We also support barring operators with too many high-risk wells from relying on blanket bonds. However, TCS does not support allowing operators to cover any number of at-risk wells under blanket bonds. If the state pursues the current structure, we urge it to decrease the percentage of at-risk wells that can be covered under a blanket bond. Third, TCS supports ensuring adequate bonding immediately after well transfer. Too often, wells near the end of their productive life are passed to smaller companies that cannot afford reclamation. Eliminating delays in updating bonding helps prevent those costs from falling on taxpayers. In closing, these updates are not punitive, they are fiscally responsible. Every unreclaimed well today is a potential claim on the public's purse tomorrow. By acting now, Utah can ensure responsible operators remain in the field and keep cleanup costs off the state and federal ledger. Thank you for the opportunity to speak today. I would be happy to address any questions, and we intend to submit additional, more detailed comments to the committee during this comment period.
Okay. Board, any, excuse me, any questions of Tyler? Okay, I don't see any questions here. So we got to figure out what to do with the rest of the day. Oh, yes. Okay, do you want to do that now, or should we take a lunch recess and then you put your thoughts together? Because there were quite a few things that came up, and maybe if we took a recess for lunch, let you guys collect your thoughts, because you're sitting on other ends of the room, haven't had a chance to talk, and there are a lot of things. But before I do that, I know we have a lot of out-of-town folks. So do we have flight issues if we pause until 1 o'clock, say, to give people a, I mean, don't want you to miss it since you've come all over here. What's your, okay. Oh, okay. Yeah, you better go. I suspect, yes.
I mean, they already had their speaking time.
Yeah,
They don't need more.
yeah. Okay, so we're not going to decide anything today. We're just going to get additional comment back from the division. So that will be recorded, so I think you can get your hands on that.
They said they're good with that.
Okay, so let's go ahead and take a recess until 1 o'clock. Will that give you enough time? 55 minutes? Okay, let's take a recess till 1 o'clock and we'll re-adjourn at that time. We're off the record.
1.
Okay, welcome back to our oil and gas bonding rulemaking comment period that we're having. I see Mr. Thomas and Megan are here to make comments. So I'm just going to invite you to go ahead and respond to those things, and then the board will ask questions if we don't hear the responses or hear the topics we want.
Thank you, Chairman, members of the board. Again, my name is Mick Thomas. I have Megan Crocker, who's one of our program managers in oil and gas, here to help address any questions the board may have. I think, well, first of all, I apologize for missing a portion of the comments. I had a meeting with Executive Director Ferry that couldn't be rescheduled, so I'm glad to be back. I would like to set a little bit of an image for everybody here on the board. Remember this, we appreciate all of the comments that have been made. As you all know, this has been an almost 6-year process, and other board members have come and gone, and this has been a cumulative effort, and me just in the last part of it. We're in a comment period now that's about roughly right at 45 days long. And when comments are received, we have oral comments today, which are meaningful, but don't take the place of written comments. I also want to say that any responses we give to questions the board may have, we're going to ask that the board also understand that the division may take additional time to provide more detailed written comments. It's not impossible, but it's something to be cognizant of when we offer off-the-cuff responses in real time, right? We have especially Megan and her team, Jen and her team, very, very smart, very understanding, can give you a lot of information, but please understand that these comments will be responded to in writing with those comments that are received in writing. We encourage stakeholders to submit their comments in writing and continue to do so through April 30th of the comment period so that everything is out there for the board. We're also asking, rather than we immediately start offering a rebuttal to every comment that was offered today, because I think I would really like to be able to do that in writing. If the board has specific questions they think need to be addressed verbally, that we're ready to do so. As you think about your questions, keep that in mind. I am not asking my staff, including me and Megan, to systematically go through everything that's been said over the past 2 hours, right? I think we all understand that. The bonding calculator went live during meeting, I think early morning. We invite operators to go in and use it. Maybe some of their concerns have been addressed, maybe not, but please, operators and stakeholders, please go in and use that calculator. And finally, overall, with the current draft that the division has submitted to the board, we saw a net increase in state bonding of just over 37%, about $6 million statewide. That's the general amount of bond that the state will hold. I want to say again, that fully meets the requirement that initiated this, which was the 2019 audit. There has been meaningful good work done by all parties. That said, finally, these are the board's rules. If you all can each, obviously, through a majority, can direct the division to make any changes that you see fit. And we invite you to continue to take ownership of these rules, and we're happy to help in any way. So there's my opening comments. If the board has any specific questions they would like for us to address, please do so now.
Go ahead, Mr. Church.
Yes, Director Thomas. I've had the opportunity to observe many of the stakeholder meetings that you've had, and I've been very impressed with the give and take. What I'm wanting to know now, you mentioned that with these written comments that come in, does the division respond in writing to the commenters about their comments that they are making now during this period?
For this comment session, we will respond in writing to each comment. Some of the comments, you all probably know, have been consistent throughout the process. Well, we'll go back and take that answer. Is it still applicable? Yeah, and we'll paste it into the new one. We also have some new comments that are coming in that we'll respond to in writing. If a written comment comes in, we will respond in writing.
Okay, thank you.
You're welcome.
And all of those written comments are part of the public record.
You're correct.
Right. Okay. Okay. Good. Okay. Board, other questions? Go ahead.
Once you consider all of the comments that come in by April 13th,
30th. Yes.
then are you prepared to come up with a final draft that we could send to formal rulemaking? How do you see this progressing through the next months?
The comments that come in during this comment period, we will respond to. Meaningful changes, I think, need to be vetted with a very high bar. At this point in the rulemaking session, rulemaking process, because we are in formal rulemaking, I don't imagine we'll have robust changes to that draft. If there is one, we would recommend we would do that. But understand that if we change the draft, well, it could open up another comment period. You see why we're so cautious to do that. That's what got us here now.
Right.
So I think ideally we hope that we'll be able to resolve comments with recommendations to the board and say, here you go, and with a draft that then is presented to the board shortly after the end of the comment period.
And so that would be at the May board meeting.
Correct.
Okay. Thank you.
Mr. Thomas, or Director Thomas, did I understand you to say we are in formal rulemaking at this point?
We are at this point.
So this is formal making.
You are correct.
But after April 30th, then there is still a comment period?
No, the comment period ends on April 30th.
And that's the permanent end?
That's right.
Okay.
Unless, through comments, we need to continue to get this tweaked in, dialed in.
Okay.
Did we send this to formal rulemaking at the last meeting?
We sent this to formal rulemaking, I think, as of January 1st. It was at the November.
Because I thought we were still in the informal.
No, we asked the board to allow it to move to formal rulemaking at the November meeting, I believe.
I thought it was the November one.
Yeah. Thank you.
So do these comments then go to, do they come just to you? Do they go up to the Capitol, to the whoever does formal rulemaking, or how does that work?
And I think Natasha's in the room, but I'll do my best to answer this. The comments are part of the public record. They stay at the division level. They're public as we vet through it, and then we offer a draft to the governor's office.
Okay, thank you.
Okay, I've got a couple specific things I'd
Go
like
ahead.
to ask about. So, one of the operators wanted to address conductor pipe as being an at-risk well, and I'd like to understand what the division's position is on conductor pipe, because to me it's just a hunk of metal in the ground. It's not a well, but I'd like to hear what your thought process is.
I'll defer to Megan on that. Thank you.
Yeah.
Yeah, Megan Crocker with the division. Currently, the rule, we changed it to OPSC and OPS. And so operations suspended, drilling operations suspended. And if it's just conductor, it's not part of the rules, and you wouldn't have to it wouldn't be considered an at-risk well. But any well that's above 500 feet, then that would be could be considered an at-risk well. So the conductor pipes we're not worried about. They are just usually between like 80 and 120 feet. Okay. And so we don't consider those a risk. It's the wells that are drilled surface casing, intermediate, or fully drilled, and they have, downhole issues, or maybe they have a fish in the hole. Those are the ones that we would consider at risk versus the conductor, which are not.
Okay, so it's 500 feet is the...
Yeah, we put 500 feet.
Okay, all right. Also, on the 5-year review, on the up to 5 years, what is the division's thoughts about having that verbiage in there on the up to versus just leaving it at 5?
Thank you, Chairman. And again, in all of this, these are the board's rules. We think that having up to 5 years provides a degree of flexibility for the board to address, I think the board could decide significant need for change with this new draft. This specifically, our bonding rulemaking hasn't been tweaked, as you know, since 2002. That's been said repeatedly. These rules were significant changes. The wording you have before you now is not a paragraph here and a line over there. These are significant changes. And we especially imagine over the next 24 months, ideally everything continues to work beautifully, but there may be something that comes up that the board would need to act on. And so we think giving up to 5 years opens that, keeps that available for the board. We would recommend that the board not consider anything trivial. This is a lot of work. Hundreds of staff hours went in, maybe thousands of staff hours went into these rules. There's a significant cost to the state to get into a project like this. And so we offer caution while saying the board has the flexibility to do so. That said, if the board determines that they will be set at 5 years, something could still come up, and the board has the authority and the prerogative to initiate rulemaking at any time.
Mm-hmm.
And so you could say, we are initiating rulemaking here if there was a finding of these rules that needed to be addressed. So I hope that's an answer for you, Chairman.
Yeah, okay, and I would be a proponent of keeping flexibility in rules, because I've written rules before that were not flexible and they were painful, still painful, so, in other jurisdictions. Okay, let's revisit the whole numerator denominator discussion a little bit with us, if you could. I know you have a justification for it. I just can't remember.
Well, you think so? I'm sorry, go ahead. We're having some side conversations. Go ahead,
Yeah,
Chairman.
okay, so just revisit the whole numerator denominator issue that people have brought up. Just, and again, we're not going to hold you to it or anything like that. I just wondered.
So I was not in here for that specific comment. Are you talking about the at-risk wells?
Yes.
Okay. The state of Utah is among one of the top 4 states of all producing states as far as small percentage of at-risk wells and, frankly, P&A, plug and abandon wells, versus well majority and production. It is an incredibly healthy state, which is incentivizing for a lot of operators to come here. One of the hardest things that staff has done, that we've all done, including you, board, is evaluate what is the true risk needed to address in revising these bonding rules. Setting the percentage, for example, like a tier 1, up to 20% of their, for a tier 1 operator, up to 20% of their total well count can be considered at risk. Currently, our field and our industry in Utah is so healthy that few, if any, of the tier 1, of the top tier operators go past that 20%. That's a reflection of very good field management by the operators and the division, smaller, mostly the operators, right? But we still think that setting that 20% provides a guardrail for if any operator moves into a place where frankly, they have a lot of shut-in wells or at-risk wells. We provide that boundary, so if it does cross, we're able to achieve additional well bonding to protect the state. When we looked at isolating wells that the state is responsible for, which is specific, not on federal land, because we're not responsible for remediating wells on federal land, and then only looked at those wells that are on state land, we found out that there was actually it was not an accurate reflection of the true operator health, because they may have had a lot of wells that are doing very well on federal land or vice versa, right? And so we really thought a lot about the denominator-numerator discussion there. And we thought the best indicator of operator health was all of the wells that they have in Utah, federal and state and private. But we are not allowed, or it doesn't make sense for us to calculate bonding needs on wells that we're not responsible for bonding. because we wouldn't have to put money toward that anyway. We'd be flush with money that we could never spend, in theory. That may be an extreme example. That's why we are here. And again, the Tier 2 operators would be at 13%. At Tier 3, I think it's 8%. So as the operators, well, everybody fits into a certain level in the industry. The true risks, normally, if ever, are these top tier operators. So we didn't see a rationale or a justification to increase their bonding amount significantly when the risk is actually with unfortunately some of the lower producing operators.
Go ahead.
In this process, we've talked about federal, state, and fee. What about tribal?
Yeah, go ahead, Megan. Thank you.
Per our current calculator, we have mixed minerals in there, and so the calculator hasn't changed regarding mineral ownership since the previous drafts. And so if there's really big concerns, like if it's only tribal well, I think the operator should definitely talk to us and email us and say, hey, there's an issue here. But we were still including those mixed mineral wells in the calculator.
So what if it's all tribal?
Then it wouldn't be in the calculator.
It
It would be
not.
considered part of their total wells, but it wouldn't be part of their state at-risk wells.
Okay, thank you.
So I had a question on one of the comments today, which you will be getting as a written comment. Gave a representation of 2 cases, and maybe they're outliers, where there was not going to be any wells put in their at-risk category as far as blanket bonding. When you get the written comments in on that, the EDF said that these 2 cases were actual cases. Could you kindly ask them who the operator is and find out if Division also thinks that those are accurate representations?
Certainly, and in fact, Chairman, Commissioner Church, I think the fact that you just said that, indicates to EDF that they should probably indicate those operators. So, thank you. But if that's not, we'll recommend that.
Thank you.
So
And just ask,
Go ahead,
clarify the
Megan.
question. Can you clarify what the question was, just so I can write it down properly? It's
Uh,
which operators don't have supplemental bonds?
EDF gave a representation of 2 actual cases where there would be no at-risk wells, not at risk.
No bonds that have supplemental
Yeah,
bonds.
no supplemental
Yes.
bonding wells.
Yes, that's accurate.
Yes.
Those examples are accurate.
That's what I meant.
Yeah.
Okay, thank you.
So most of the people who spoke, gave a presentation. Are those all considered in? Is everything that was brought up today going to be submitted as you'll respond to in written form?
Chairman, Commissioner Galecki, the division will respond to written comments first in writing. We'll also evaluate today's transcript,
Okay.
right, to see if there was anything discussed today that hasn't been provided formally in writing, and we will respond in writing to that.
Okay. Thank you.
So going back to Mr. Church's question, specifically on those operators, they obviously had large numbers of federal wells, so their denominator was large,
Right.
and so resulting in no supplemental bonding. So thinking about those operators, is their bonding amount, is it represent an appropriate amount in your humble opinions?
Chairman, Commissioner Moon, that's the most difficult question in all of this, because you're really trying
But I
to
guess
do-
my question, though, is more, does that cause alarm? Is that like, oh, oops, we missed something? Or does it feel like, okay, based on their size and their health, and we considered, we knew we were putting it in the denominator, and
Certainly.
it was there. Does it feel right?
So I cannot say yes or no to that, frankly, because we had to evaluate and just there's a fair amount of instinct and a lot of robust conversation between some people within the division. I'm one of them. about what's the spot, what's the sweet spot. And there are just correct opinions on both sides of that question.
Okay.
We did the best we could to come together with a recommendation to the board. And of course, I put it back to you all. Listen, feel your gut and make recommendations to us if you want to go in a different direction. This was the best we could do after a lot of work. But the call is ultimately up to chairman and each of you board members.
Yeah, and my question more isn't, it's not like,
Yeah.
my question is just more general, like, okay, did it do what we thought it should do, or was that kind of a surprise? Oh, maybe.
I'll say this.
You're answering my question.
Yeah, I'll say this. I think it's in the right spot because we have had significantly less bonding over the past several years, even few decades, without any horrific risk to the state. Now, operations are changing. The field is still healthy and still growing. Wells are aging. Large number of wells will age out over the next probably 5 to 8 years. We understand how the industry works, right? And, I think that's on the horizon. But as it is right now, I personally believe that we're in a place that is a good middle ground to incentivize growth and protect Utah.
One of the other topics that was addressed by numerous parties was the categories of shut-in wells. Do we have a good definition on temporarily shut-in wells, inactive wells, and temporarily abandoned wells that makes sense and also works with, that's other parts of our regulation, but does that flange up with our bonding issues here?
Yeah, I think there's a little bit of confusion with some of the definitions. Shut-in is a one-time status. So if a well is shut in, it could be shut in for a month, could be shut in for a year, it could be shut in for 5 years. TA means that there's a plug over the perforations and you are unable to produce that well. Shut-in means it has the ability to be produced. TA means it has no ability to be produced at that time, and usually it's a permanent plug. When we talk about inactive, that just means the well is not currently injecting. Active is currently injecting. When you talk about the shut-in TA rule, that's a specific rule that says after 12 months of being shut in, TA'd, or inactive, then you have to do something with the well, with the division. And so then it comes to my team. We run a list, and so every month we run a list looking for those wells that reach that 13th month. We run it on the 13th month. And then we notify the operators to say, hey, you have this well that's been shut in for 12 months. What do you want to do with it? Do you want to plug it? Do you want to produce it? Do you want to keep it for future utility? And then operators will let us know what the plan is. They can get an extension if they MIT the well. They give me a reason it's shut in and the length of time that they want. We only approve up to a year. And so then they can get an extension on those. But they're still shut in. There's still zero production. There's still zero injection on all of those wells. When it gets to 5 years, that's when we encourage them to plug them. So they might say, hey, we're going to recomplete it for first year. Hey, we're going to still want to recomplete it. We're waiting on, economics or like rig availability. But then at that 5 year mark, that's when we say, hey, you really need to decide. At some points, we'll get additional bonding out of them, depending. Like if you really want it over 5 years, you're waiting for like an injection well permit. Then we'll be like, okay, well, put up some bond, give us a reason, and then you can get an extension for it. But I think we need to, just to remind you all that those wells are still shut in. And per the way we're writing the rule is if it's 1 BOE or less, and 0 is less. And so that's why we still think it's imperative to keep that as part of the at-risk well calculator, because even if you do have a valid MIT, it has downhole work, but that doesn't talk about the economics of the company. Like, we don't look at that. And so I think it's really important to keep those as part of the at-risk ratios.
Okay. Now, one of the commenters said you don't make an economic assessment of any of this stuff when it's shut in. But I just heard, sounds like you do. Or what's... I understand the mechanical integrity part of it, but is there a formal or even an informal look at the financial risk?
Generally, no, we don't look at that until 5 years. But at the 5-year mark, economics is not a valid reason to keep it shut in anymore. There's, I can't remember there's I don't know if it was a litigation or lawsuit that says, the reasons how you can keep a well shut in past 5 years, and economics is not one of them at that point. But for sometimes, like in the short term, you can do that a little bit. If you can't get a rig too, like that's a good reason for keeping it shut in, because sometimes
He's more talking about the economic viability of the company.
yeah, we don't look at that. We don't look at that during the extensions. We just want to know that you have integrity because one of the concerns with the shut-in TA rule is the longer a well's been shut in, the more it can have issues. It might, have more potential to leak. And so we want to protect the surface and the environment and the people from those kinds of things. And that's really what the intent of that rule is.
Okay. Yeah, I totally agree on the safety issues, on mechanical integrity.
So let me just stick with that one.
Go ahead.
So there is kind of built in a 1 year period where that's not in the at-risk pool.
No, it is still in the at-risk. It's
Oh,
all
it is.
based on numbers, and so
when
those
is
wells.
it evaluated and put into the at-risk calculation?
Once it has 1 BOE on average per the last 12 months of filed production.
So immediately or after the 12 months?
It really depends on the average, and so like if you produce it for 5 MCF for 1 month, in a 12-month period, that would fall under the 1 BOE per year on average. And so we look at a whole average
as soon as
for
the
it.
average drops below 1,
Yeah.
then it goes in.
Yeah, so
So
once
there-
it's 0, so like then you'll look in our database, it'll show zeros for the last 12 months. That's when the shut-in TA rule comes through. And
Okay.
so like shut-in TA, inactive, those are individual statuses. Those are just a status at one time. The shut-in TA rule is different than that, and that's has a timeline associated with it.
Okay, I think I understand, but let me just
Okay.
make sure.
Okay.
So say it's shut in this month, and then shut in for the next 5 months. Has it gone into the at-risk pool?
It is at risk if that average, unless you'd have to really look at the average of the 12 months, because maybe it, had 200 barrels, for one of those months.
Okay.
And then, they went down, whatever that average is for that 12 months
When
of
the
production.
average drops below 1,
Yeah.
then it goes in. Okay. So you kind of have maybe a 6-month leeway before it goes in, roughly.
Yeah, it really depends on the
Depends
math
on-
and
okay.
what kind of production it has. So, some are very minimal, some might be a lot higher.
UPA is requesting a 1 or 2 year grace period. And I'm just trying to understand how much grace period there already is on a well that's been shut in.
Let me ask something.
Oh, sure.
Excuse me, Chairman, Commissioner Moon. I think the question in a word picture is you have a well that they turn on and flow for 1,000 barrels 1 month, every 6 months. Would that well over a 12-month period ever fall into the shut-in TA?
It would.
And the answer, I believe, is no.
No, it wouldn't.
Okay, does that help you understand
Yeah.
the response?
Yeah. So
And
if
that's-
it's shut in for a frac, it's not going to fall in.
That's exactly right. I mean, we understand there's a need for operational buffers and stuff to turn wells on or off. We definitely appreciate that, and I'll go back to communication is key. In all of this, communication is key. If an operator is transparent with our field staff, Megan and her team, about what and why they're doing, it's going to put her at ease to have an idea of what's going on. Not that there's a lot of discretion here, but communication is key when we're saying we're going to shut in these 20 wells in this field to do a workover, or we're doing this other thing. Communicate on that. But the math, I think, what the story I just told you should serve to address your concerns. Okay, thank you, Megan.
Okay, I've got a question on, Ms. Beatty presented a semi-log plot that showed at the end of it that appeared that large producers got a get out of jail free kind of card. You probably weren't here for that, but I don't know if you remember that, Megan, that
I guess, what is your question regarding it?
Yeah, can you address how that's appropriate that
I think that was showing the old rule and how the old rule was not, I think, wasn't it?
The chart that I was thinking of is showing where it's full cost bond versus current bond versus the new bond. Is that the one you're talking about?
No.
Or you're talking about a different chart?
This was a semi-log plot that showed, number of wells on the left, I think it was. If I got that right.
I can bring it up if that would be helpful. There were two plots. And then both plots had, expected liabilities on the y-axis and projected bonds on the x-axis. One was projected bonds under the current regulation, and the next was projected bonds.
That's pretty hard to follow that. So could you take a minute to do that, please? Okay.
So for clarity, Chairman, you want us to wait until she comes back up?
Yeah.
Okay.
You weren't here for it, and
Certainly.
Yeah, but I'd like to kind of get their thoughts on what you presented at that time. Not that it's right or wrong. It's just I'd like you to guys respond to her.
I don't know if you want to go up there.
That slide.
Yeah, that's the one I was thinking about.
And maybe it's not that one. Not that one. That one. Yeah. Yes. So what that's telling me is that in situations where we have a really large liability, the bonding is about an order of magnitude off, if I'm interpreting that semi-log plot. Oh, no, it's a log-log plot properly. Can you guys take
I think
maybe it's hard to
I think the best thing to do, rather than take this out, and I'm definitely not punting, would be the division go back, evaluate the transcript as we talked about earlier, to allow us to fully understand Ms. Beatty's presentation, and then provide a written response to that presentation.
That works for me.
I commit to doing that.
Okay. I'm impressed that somebody shows up with a log plot. That's good.
Yeah,
I talked to my grandkids about it, and they don't, what are you talking about? Yeah.
Thank you.
Okay. Other questions? Okay, so again, as you've already requested, Director Thomas, that everybody should submit written comments again. So in a lot of cases, this is the second or third time we've heard these, so there shouldn't be a big burden to deal with all those written comments. And we need to need to have those done by April 30th. Now let's not let perfect get in the way of very, very good.
Certainly.
So we do have a goal of trying to get this done in the not too distant future. If we have to do one more comment period of 30 days, we can do another comment period, but I'd like to have it as a goal that we get there within the next two comment periods.
Thank you, Mr. Chairman. That's our intent as well. And I imagine all stakeholders would like to have this resolved
We want to know what the rules are.
Right.
Yeah. Board members have anything else that you want to talk to Director Thomas and Megan about? Let's entertain a motion to adjourn. Nobody wants to?
I move to adjourn.
I second.
Quickly.
All those in favor say aye. Aye. Okay, thank you very much, everybody. We are off the record.